May it please your Lordship, I seek your Lordship's indulgence in mentioning item number 3 of the Part 2 cost list, Part 2 hearing list, your Lordship. Item number 3.
3.
Yes, your Lordship. Though it has been fixed for the 15th, that is tomorrow, your Lordship, I have an ongoing medical treatment, so that is why, your Lordship, I will not be able to appear tomorrow. So I have taken the consent of the opposite party as well, and if this matter may be listed on some other date, your Lordship.
Just item 3.
Yes, your Lordship.
When do you want it?
Your Lordship, if this matter may be listed
2
next,
weeks?
Your Lordship, next week on the 22nd. On the 22nd.
No, Wednesday, 22nd is a Wednesday.
Yes, your Lordship. If not, then your Lordship on the 23rd.
You have it on 27th.
Yes, your Lordship.
Right. Ms. Lalnun Louis, learned government advocate, submits that although the matter is fixed for 15th of July 2026, but as she will not be able to appear on that day, she prays that the matter be adjourned for 2 weeks. Stop. She submits that she has taken the consent of the learned counsel for the other side. In view of above, this is the matter on 27th of July 2026 as paid for. All right.
Much obliged, your Lordship.
Any other mention?
Yeah, may it please, Your Lordship, I'm mentioning on part 2, item number 2.
Yes.
Your Lordship, with due respect, if the matter be adjourned for 1 week's time, with the
Your-
consent of the other party,
Hmm?
with the consent of the other party,
What is your good name?
Kelal Limpuya,
You are appearing on behalf of?
respondent number 1.
Okay. Why do you want adjournment otherwise?
Your Lordship, we need more time to study the matter.
Okay. Mr. K.L. Himpuya, learned counsel for respondent number 1, submits that we need some more time to prepare the matter and therefore prays that the matter be adjourned for a week. Stop. He submits that he has taken the consent of the other side as well. Stop. In view of above, this is the matter.
Sir, my lord, let the date be fixed for hearing. Next week, 1
This is
week.
the matter. Let the matter be listed on 27th of July for hearing. Okay.
Yes, sir.
May I seek your Lordship's indulgence in mentioning item number 13 and 14 of hearing list, my lord.
13 and 14.
Yes, my lord. My lord, as the leading counsel for the respondent number 5 to 7, Mr. Pyongsu is having an unforeseen personal difficulties. If the matter be taken up on next week, Tuesday, 21st.
Who's for the other side? Mr. Ramzawa is there.
Yes, my lord. I was informed that you have taken prior consent.
Mr. P. Goswami will be available next Tuesday.
Yes, my lord, 21st July.
Mr. Lomo Maralte, learned counsel, submits that. Are you there in this case?
No, my lord, I'm not in the list.
Submits that he has been requested by Mr. P. Goswami, learned counsel for respondent numbers 5 to 7, to seek adjournment and to pray for listing of the case on 21st
Yes, my lord.
of July 2026 on account of personal difficulties. Stop. He submits that he has taken the consent of the other side as well. In view of above, list on 21st of July 2026 as paid for. 13 and 14.
I'm obliged, my lord.
Please, Your Lordship, my lord. My lord, with regard to part 2, item number 10, hearing list, my lord. Item number 10.
Yes.
My lord, this may be fixed on Friday, my lord, if time permits.
Friday not possible. Mr. Benjamin, you have take some other day.
In that case, my lord, may it come up again on next week, my lord.
Next week. On the prayer of Mr. Benjamin Lalthamona, learned counsel for respondent numbers 1 to 6. Have you taken consent
My lord,
and not objected to by the other side? List the matter. Again in the weekly hearing list commencing from 20th of July 2026.
obliged.
20, huh? 20.
From motion column, item number 1.
Yes.
My lord, I'm very sorry for forgetfulness of
No, it's
the
okay.
court decorum. Regarding this item number 1, Lordship, this is an old wine in a new bottle. If Lordship takes page 57 of the writ petition, that is where Lordship has earlier dismissed the old wine. And as such, I request Lordship to kindly recuse himself from handling this case.
Why?
Because this is the same issue.
Can you come again and again on the same issue?
I mean,
Please tell me.
yeah, the Supreme Court has given us a liberty,
Maybe,
but
if it's the same issue already decided by this court,
yeah,
can you come for second round like that?
we are filing a new writ.
Maybe a new writ, but it's an old wine, you said.
A new writ.
Old wine in new bottle.
Yes, that's why.
The wine remains old, already decided, already consumed.
No. We have gone to the Supreme Court also, and Supreme
You
Court.
have already consumed the wine. You have been given some compensation. You have already consumed that.
No, Lordship, that is not a compensation. Compensation will come when the law is invoked under Section 11 of 1894.
Mr. Mangson How, see, whatever it may be, you have shown me this page 57, which was decided by this court.
Yes, Lordship.
Then you were not happy with that. You went in writ appeal.
Yes, Lordship.
Writ appeal has affirmed the judgment of this court.
Yes, Lordship.
Thereafter, you went to the Supreme Court.
Yes, Lordship.
In Supreme Court, nothing much happened. You sought for withdrawal of the SLP with liberty to approach.
May I put in, Lordship? We did not ask for withdrawal. The Supreme Court, the Honorable Supreme Court gave liberty to the petitioners.
You did not ask for withdrawal.
No, I did not ask.
Then how it was given to you?
The Honorable Court gave liberty to the petitioners. We have reached up to the Supreme Court. What is the point in asking for withdrawal?
Okay, then you please explain page 54. Please read page 54.
Upon hearing the counsel, the court made the following order. Learned counsel for the petitioner seeks permission to withdraw.
Read.
No, this is
Please read.
2018.
Please read.
Yes. These petitions with liberty to pursue the representation in relation to the subject matter in question. Permission granted. The special leave petitions are accordingly dismissed as withdrawn.
This was the first time you went to
Yes.
Supreme Court.
In 2018.
This was the first time.
Yes.
Correct.
Yes.
Now come to page 39.
39.
This is your second SLP.
Yes, Lordship.
Please read the order.
Upon hearing the counsel, the court made the following order. Delays in refiling is condoned. We dispose of this special leave petition by reserving liberty to the petitioners herein to seek remedies in accordance with law. Here,
And
I
one more line, pending applications, if any, shall stand disposed of. You are right, you do not seek withdrawal.
Yes, we did
But
not.
the Supreme Court has said that we dispose of these petitions, reserving liberty to the petitioners to seek remedies in accordance with law.
Yes, Lordship.
Correct?
Yes, Lordship.
So that is the order of the Supreme Court. Now, if you say that you do not withdraw, have you filed for any review or something? That I don't want disposal like that. I want the disposal of the case on merits before the apex court. Did you approach the court like that?
No,
Then?
we find it, after studying this, we discovered that it is safer to approach the LARR, Land Acquisition, Rehabilitation and Resettlement Officer of Champai. We applied, and then it was to be referred by the DC to the LARR officer. But the DC was legally stuck on reason that the accusation was in 2010, and how he could now refer the matter to the LARR officer in 2026. So there was a legal difficulties, and therefore there is no way except to come to the writ court for justice.
So how does one refer 2010 case to the reference court? Under what provision?
Under section 64,
64 says that there's some time period for referring.
time
isn't it?
period, 30 days.
Is there any provision for condonation of delay of making a reference?
That is up to the...
No. It's not up to. It's a particular special law. It's a land acquisition law.
Yes, yes.
Whether there is a provision to condone the delay in filing the reference petition.
Reference petition. We have not, actually we have not crossed the limitations. We came and filed even writ petitions here, and we withdrew it after realizing that we have to file it before the LARR.
See, you have filed series of writ petitions. All of them have been dismissed. What survives now? How do you come back for the same cause of action again and again?
There is a course of action.
What is the cause of action? Tell me.
Course of action is that our rights have been still not redressed.
Your rights have not been redressed. What do you mean? The court has dismissed your claim.
Which court?
This court has dismissed your claim.
No, we have
The
not.
writ appellate court has dismissed your claim. Supreme Court has not declined to not to interfere with the orders. It says you go and do whatever you want in accordance with law.
Yes, yes, Lordship.
Now tell us, what is the ground for filing this writ petition now? On what basis are you filing?
Our rights have not been restored.
As so far as the High Court is concerned, it's already final. I don't think there's any scope for coming back with a fresh petition and again like that.
And if Lordship,
See, the remedy which was available to you was before the apex court. Apex court also did not say anything. They said, okay, we dispose it of reserving liberty for you to pursue your remedies in accordance with law. Then as per law, what remedy is available to you? Tell me.
Lordship, please accept this
What is
ruling.
that? What is that?
Oh, praying for recusal of Lordship from handling this case. Please turn page 5, second para.
Page 5,
Second para.
is it numbered? Page,
Yes, it's numbered at the bottom.
where is it numbered? Okay. Page 5, second para.
Yes.
Read.
A basic postulate of the rule of law is that justice should not only be done, but it must also be seen to be done. If there be a basis which cannot be treated as unreasonable for the litigant to expect that his matter should not be heard by a particular judge, and there is no compelling necessity as to the absence of an alternative, it is appropriate that the learned judge should recuse himself from the bench hearing that matter. This step is required to be taken by the learned judge, not because he is likely to be influenced in any manner in doing justice in the cause, but because his hearing the matter is likely to give rise to a reasonable apprehension in the mind of the litigant that the mind of the learned judge may be subconsciously has been influenced by some extraneous factor in making the decision, particularly if that it happens to be in favor of the opposite party. Credibility in the functioning of the justice delivery system and the reasonable perception of the affected parties are relevant consideration to ensure the continuance of public confidence in the credibility and impartiality of the judiciary. This is necessary not only for doing justice, but also for ensuring that justice is seen to be done. So, relevant to this prayer, I'm asking Lordship to kindly recuse himself from handling this.
Why? Give me one reason why I should recuse myself.
Because Lordship, I have asked you to refer page 57, wherein Lordship has passed a dismissal order
Correct. On the same subject.
on the same subject.
So today also we are faced with the same subject. What do you expect? Are you bench hunting?
I am not bench hunting.
Perhaps this is called bench hunting.
I am not bench hunting, Lordship.
If Judge X is not favorable to me, I'll go to Judge Y. If not Y, I'll go to Judge A. Can you do that?
No, Lordship,
Then,
this is not bench hunting.
no, why should
Because
I
of
recuse
the-
myself?
No, because of the precedents, past precedents, that is page 57's ruling.
See, your case is already a decided matter insofar as a single judge and a division bench is concerned. So, this is the law, Mr. Counsel. Please try to understand. We cannot again and again decide a case. Your matter has already been decided by the single judge, rightly or wrongly. Then you file writ appeal.
Yes, Lordship.
A writ appellate court also agreed with the learned single judge saying, yes, we don't find any reason to interfere, upheld. Then you go to the Supreme Court. In the Supreme Court also, it is not decided on merit. It's either withdrawn or it was disposed of, saying that you seek whatever remedies available to you in accordance with law. Now you're back to the High Court again, saying that please reconsider and re-adjudicate this matter. Can it be done like that?
Not by the
I'm
court.
afraid it's not possible, Mr. Counsel.
No,
It's
no.
not possible.
There is a way. That is why we come.
What is the way? Tell me.
The only way is to hear the.
It will be rehearing the matter. It will amount to rehearing the matter or a review sort of thing. Can it be done like that? It's not even a review petition. It's rehearing the matter.
It may not be a rehearing for the court which is handling it.
This is what the law says. We cannot rehear. Your judgment which you have referred, he says that the reason is that there is a reasonable apprehension in the mind of the litigant that the mind of the learned judge may be subconsciously has been influenced by some extraneous factor. Correct? This is in a different scenario altogether.
Yes, Lordship.
In the present case, nobody is influenced by any extraneous factor. The court is not influenced by any extraneous factor. Only thing is that the court is, what is placed before the court is a judgment rendered by the court dismissing the writ petition. There's no question of being influenced. It was dismissed, it is dismissed. You come back with a fresh cause of action, definitely will entertain it. But then again, you come and cite the same chorus that I have not been given adequate compensation. That aspect has already been looked into by the court. There's a principles of res judicata also.
Lordship, page 1 of writ petition, the prayer in the matter of
Page?
page 1 of the writ.
Page 1. Yes.
So,
Page 1 is the index. Page 1 is the index.
in the matter of,
First page is the index.
no, the main petition,
So what is the page number?
page 1 of page.
You have two page ones.
Yeah, this index is index after the list of dates, the main petition.
Okay. Yes.
A joint petition application under Article 226 of the Constitution of India and for violation of the Article 14, 21 and 200A of the Constitution of India.
Not 200A, 300A.
Sorry, 300A. Thank
Now-
you, Lordship.
Just pause there for a moment. What do you mean by a joint application? Who has joint application?
Farcon.
Who and who?
Farcon and Concon villages are filing this.
How they file joint application?
That is the same subject matter.
Huh?
Same subject matter.
Who are the petitioners?
The petitioners are here, listed in page 2. From page 2, page 3, and page 4.
Can it be filed in such a manner? Now, who has sworn this affidavit?
Lordship,
Who has sworn this affidavit in the writ petition?
Lal from Puya,
Who is he?
attorney of Concon village, Concon petitioners.
He is the attorney of Khankon.
Yes, Lordship.
Has he been authorized to file this writ petition?
Yes, Lordship, Lordship.
Where is it written?
Let us turn page 29.
29. It doesn't say so. It's basically to represent you before the court.
For the authorization, it is here at page 38.
38.
Yes, page 38. There is in Mizo version. English version.
Letter of request.
There is a request to the power of attorney. 37 is the Mizo version.
You mean to say you filed the writ petition on behalf of the villagers of Farcon
Farcon 2.
on the basis of request letter?
Request letter from the power of attorney.
What is the value of request letter? Tomorrow you send one request letter to Mr. X and go and file writ petition. Can it be done like that? On the basis of request letter? I think your writ petition suffers from multiple defects, Mr. Counsel. And particularly when the issue has already been dealt with by this court, both by the single bench as well as the division bench. I don't see any scope for entertaining the writ petition again, once again, on the same issue, on the same prayer. You come to page 156. You had earlier filed WPC number 29 of 2026 this year. You had withdrawn that on 20/4/2026. The same tentative view was perhaps given to you that day, and therefore you withdrew it. But again, here you are today filing the same writ petition on the same cause of action, and you're asking for this court to recuse from hearing this matter
This petition,
because this court had dismissed your writ petition at one point of time on the same issue, same cause of action. Your
This-
prayer is not acceptable, Mr. Counsel.
this writ petition is praying for direction to exercise supervision to the court of Champai for registering the cases filed there.
To supervise Champai Court.
Champai court,
How to supervise them? Why to supervise a court?
because Champai court was,
Champai Court is Champai Court.
no, Lordship,
It matter whatever court it may be. It has its own power. Whatever matters dealt with by the court is strictly within its jurisdiction. This court may not interfere with whatever they do unless
Let
they
me
come up
finish.
with some decision which perhaps is not in accordance with law. Then in that case, by way of an appeal or by way of any other revisional jurisdiction, those things can be entertained.
can I speak
But
now?
every court has its own right to dispose of a case within its jurisdiction, within its limited, within its powers.
Can I speak now, Lordship? Now in Champai, what I encountered was that when I was filing this under specific relief act, they were confused as to the jurisdiction. So I could not file it and they could not register it. So I came here to ask for supervision of the court. And in the meantime,
We don't supervise subordinates or the lower courts, the trial courts, by
On the
way of
227
Article
we have.
226. Huh?
227. I was filing under 227.
Where is 227?
This is about 227.
Come to page 1 of your writ petition. It does not speak about 227. It's your imagination. Don't submit beyond your pleadings, Mr. Counsel. I don't appreciate it.
What's which one you are? Please point out. This is file under 227.
Please point out that 227, where is it? Come to page 1, the second page 1. Have you got it?
No, I don't get it.
It's your writ petition. It's not, it's your lookout. If you don't get it, then it's up to you. It is your writ petition. You have drafted it. You don't know where your things are. How can we help you?
I have not brought that writ petition.
Which writ petition?
227.
That
Writ petition
227
for which order was given.
Oh, that 227 is not before us. You are talking about 227. There is no 227 writ petition before this court as of now.
No. Which page are you talking of, Lordship? Please kindly clarify again. Page. Please. So magnanimity.
Okay, for the last time, I'm telling you, you are saying that you are seeking the supervisory jurisdiction of this court because the court in Champhai is unable to take a decision. So you want the High Court to supervise that court. I say, under what provision? You say, under 227. Then I say, where is 227 in the cause title? You cannot show me that 227.
No, that one is decided here. Decided under this.
I don't think that's the case, Mr. Counsel. Your writ petition will be dismissed.
On 2026, I have asked for withdrawal with liberty on discovering that there is a notification on the 20th of December.
Maybe. I think I've heard enough, Mr. Counsel. Your writ petition will be closed, dismissed. Next case.
Item number 2.
You show it as disposed. Next, yes. Yes, Mr. Liansuna.
May I please, Lordship? This petition is for about electrocution case. In fact, the petitioner is a minor, is at about 7-8 years, and he is represented by his father, my lord. Facts of the case in brief is that the minor petitioner, while playing with his twin brother on the government middle school premises at Keitum Field, Veng, at Serchip district, climbed onto the roof of the school building and accidentally touched the low-hanging electric live wire and suffered an electric shock. My lord, he was taken to the district hospital, Serchip. However, he could not be treated there properly, and he was referred because there was no, due to lack of medical facilities and due to non-availability of medical expert to this in this connection. Therefore, he was referred to ZMC, Zoram Medical College, where he was kept. Considering his nature of injury and his conditions, he was kept in the ICU, my lord. And as per the injury report submitted by the concerned medical authorities, the petitioner, minor petitioner, suffered electrical burns injury of 45 to 50% of total body surface area, and the injuries sustained by him was grievous and severe. My lord, the actual condition of the petition is described here in my petition at Paran 9, my lord. I'm just reading with lordship permission.
Yes.
Paran 9 of my petition, my lord. That even after taking medical treatment at the ZMC, the left popliteal region and surrounding areas developed burn injuries. Multiple blisters developed after burn injuries, which are very, very itchy and unendurable. In fact, topical ointment treatment was given and no other remedy was possible as claimed by medical authorities. The minor patient, petitioner, reportedly developed painful restriction of movement of the left knee and he actually walks with a flexed knee gait. He is not able to fully extend the left knee due to severe pain and walks unevenly when in state standing position, my lord. That is the actual condition of the minor petitioner, my lord. Therefore, we have filed the instant petition for compensation. My lord, one more thing I would like to add to in this connection is the petitioner and his family are very poor, living in a remote village at Serchhip district, and have no money at all to take further treatment. The only treatment they could get from ZMC was done as far as the medical authorities is concerned.
Now, what is this Annex 12,
Annex 12.
page 53? Ex gratia, accident,
Yes, my lord.
And all that.
is, they were rather instructed to file, they were in fact informed that they would be getting rupees 5 lakh as per the government notification. And they were instructed to file affidavit to this effect, and they have done so. And my lord, affidavit also I have been enclosed along with the petition.
Have you been awarded any amount?
No, my lord, not a single price is given to us.
No. Have you approached any authority?
We have, and
How?
we have approached. In fact, my lord, as per their instruction, we have filed this consent affidavit, which is to be found at page 52, my lord. There is the consent affidavit. That was done as per instruction given by the Power and Electricity Department concerned.
Consent affidavit.
Consent affidavit was filed by us, and it was submitted to the concerned authorities. There is PNE. However, even after several weeks have passed, they could not give us. Then they said that you are not entitled to get anything as per the notification, which is to be found at page 53. That is the notification regarding the payment, ex gratia payment. My lord, at 53, earlier we were informed that disability up to 21% to 50% can get 5 lakhs rupees. So therefore, we were instructed to file consent affidavit. We have. However, for one reason or another, we were not given anything, and we were informed that we would not be getting anything. So they returned the original consent affidavit also to us, saying nothing is to be expected.
Do
from
you
them.
have the disability certificate?
My lord is here. We have enclosed.
Page?
Page. Injury report is found at page 7, my lord.
Not injury
sorry.
report, the disability certificate issued by the competent authority.
My lord, apart from Annex 7 injury report, no other certificate is given to us. In fact, my lord, the concerned authorities, that is Associate Professor Department of Surgery, ZMC, refused to give us any other certificate. My lord, here, in my opinion, I'm reading with the lordship permission, the injury report, page 22 on the following page, page 21C. Opinion of the medical officer. In my opinion, the patient is suffering from 2-degree electric burn injury, around 45 to 50% TBSA, total body surface area, which is grievous in nature. Apart from this, Malati is refusing to give us any certificate. If need be, my lord, this Honorable Court can give direction to the state government to constitute a medical board to examine the minor petitioner on whether he was suffering from permanent disability. As of now, the concerned professor refused to give us any thing in writing, my lord.
No, who will give you disability certificate? Not the hospital.
Not
There has to
the
be a medical board for that.
medical board is usually constituted for that purpose, my lord.
Are you not supposed to apply for that?
No, for
this-
us, even
this-
if we apply, they will not listen to us.
No, that is another thing, you see. But you have not applied. You have presumed that even if I apply, nothing will happen. But you have to apply first. And if they deny you, then it's a different thing.
That is
But
correct,
even
my lord.
before applying, you're saying that I'll be denied. There's no point in applying.
My lord.
How can that be?
That is true to a certain extent. However, my lord, so far as the
You know why I'm saying this? Because this notification, which is gazetted,
my lord,
it talks about the amount of compensation which can be given.
my lord,
And that the quantum has been fixed depending on the percentage of the injury.
right, my lord,
So you yourself cannot say I am 50% disabled or 30% disabled. Somebody has to certify you. The board will have to certify you that you're disabled to this much to this much.
my lord.
And if you produce that certificate along with the affidavit or whatever they call it, then whatever amount has been fixed here should be given to you.
That is true, my
But
lord.
if you don't have that certificate, the P&E department cannot simply presume that you are eligible or you are not eligible like that.
That is
First
true,
thing
my lord.
first is requirement is that disability certificate.
Initially, my lord, on seeing the injury report saying, which is saying 45 to 50% TBSA, the concerned authority in the P&E department said that you are entitled to get rupees 5 lakhs as per the notification dated 13 April 2021. So, accordingly, we will
Correct.
file.
That is neither here nor there, you see. They may
My
have
lord.
said that you are entitled to please do something, and ultimately they have not given you. And now, even if we ask them, they will say that you have not produced disability certificate. So we cannot say that you are disabled. That is why we are not giving you. This is what they will say, I'm sure.
My lord,
That is why you are first of all, you have to procure that disability certificate, apply for the same, and medical board is constituted for that purpose. And if they fail to give you that, definitely court will look into it.
that is true, my lord. At the same time, my lord, since they are very poor and coming from a remote village, it is not very easy for them to come to Aizawl and apply for constituting the medical board in the state. See,
They have come to Aizawl, engaged a senior lawyer.
my lord,
Don't tell me that they cannot go to the hospital and get the certificate.
if your lordship knows how poor they are, then my prayer to your lordship
No,
is
definitely.
to
That
give
is why
direction.
even the department will consider that aspect.
In fact, my
I
lord,
don't think they'll charge
they have
a
considered,
huge amount to give a certificate.
my lord,
They will just say that give us your medical certificate, discharge certificate by the ZMC, whatever, the kind of treatment you have done. You come to the board, we'll examine you, then we'll certify you. So that is how things are done, I think.
my lord,
Without that, it will be difficult, you see, because this court cannot determine you are 50% disabled or 30% disabled. Court cannot say that.
my lord.
The expert has to,
Anyway, my
determine.
My prayer and my suggestion to your lordship is let the notice go and let the department concerned file affidavit, and whatever they say may be considered by lordship. Otherwise, at this stage, as of now, what materials we have is produced before lordship. We have earlier submitted
Mr.
application.
Liantrima, see, we can do that, no problem. But
My lord.
I think on your part also, you should try to get the certificate. Find out who is giving the certificate, go and approach. And if you say that I went, but they were not entertaining my application, then we'll do something about it. Without you even going there, we cannot say that you give him certificate.
The patient, along with his father, went there many times.
Where?
And requested
Where?
to the concerned Department of Surgery at
Where-
ZMC.
Where is your statement to that effect?
I have not made any statement
Then-
because
then
it
how
was
do we-
verbal. Verbally, it was refused.
No. Verbally it was refused, but at least right here in the pleadings that I went there, I was refused. So then they will have to verify, did they really refuse you or not? They will file their affidavit. But if you don't make a statement here, how do we take that into account?
My lord.
That's your
that is
submission
true.
only.
Anyway, let the notice go, my lord, and file their affidavit, and we will see.
See, don't
What they will say.
don't think that I'm being very technical. You see, but that is the
I
basic
understand,
necessity.
my lord.
Basic necessity is that if you are
I-
entitled to it, you will get it.
My lord.
But you must show that you are entitled to it by giving a certificate.
Even the concerned department has issued the electrical extent report, which is to be found at page 18 onwards, and detailed report also given by junior engineer, Nathiel Power Subdivision, my lord, a copy of which has been enclosed along with the petition, my lord, Annexer 6. Annexer 5 and 6 is to that effect. And injury report is
Where's the FIR or something? Which you
FIR also there, my lord. FIR is page 16, 16, Annexer 3. Uh, I'm reading, my lord.
No, I've read it. But what do you call this electric wire? It's just a normal electric wire.
Electric wire. This is to certify that on dated 1/11/2025 at 12:50 p.m., a written FIR was received from Lal Sang Puya, who is the father of the petitioner, of Keitum Phil Veng, to the effect that on 27/10/2025 at 2 p.m., his son Lal Lomthanga, 7 years, was playing on the government middle school premises, Keitum Phil Veng, and climbed onto the roof of the school. He accidentally touched the low-hanging electric wire, which is just about 3 feet above the roof. He suffered an electric shock. They rushed to District Hospital, Serchip, where he was referred to ZMC Serchip and is currently treated in the ICU. The medical officer has classified the victim's injury as grievous injury. Injury was conducted and no foul play was found. The cause of injury sustained by the victim, Lalom Thanga, 7 years, is due to accidentally touch the low-hanging live electric wire at government middle school premises at Keitum Philveng, Keitum. In this regard, police verification has been issued in accordance with the medical report prepared by medical officer, District Hospital, Serchi. It was signed by the SI Lalbel Thangi, Serchi PS, and countersigned by the officer in charge, Serchi Police, my lord.
You have the next one, judgment of this court,
Yes, my lord.
page 42.
Yes, my lord. They, so many judgments has
In that case, what was the disability?
6. Oh, my lord. 60%, my lord.
Sorry?
60%.
60%.
case.
Correct.
My lord.
So it was on the basis of that disability that compensation was awarded.
My lord.
So who has determined that 60% disability?
It was issued by, I presume, it was issued by the medical officer concerned.
Correct.
Medical authority,
See,
my
the
lord.
Department of Empowerment of Persons with Disability, Ministry of Social Justice Empowerment, Government of India, has also issued a disability certificate wherein it has been certified that the petitioner has a case of locomotor disability which has caused his 60% permanent disability. So it was on the strength of these documents that amount was assessed and given. In your case, you don't have that. You say that if I approach, they'll not give me. So during the pendency also you approach,
My
get a
lord, I can do
certificate,
that, my lord.
and we'll see.
My lord.
Please write hard, Mr. L.H. Liantrima, learned senior counsel, assisted by Ms. Ruth Lal Wadfeli. for the petitioner, who submits that the petitioner is a minor and is represented by his father. So he submits that the petitioner on 1/11/2025, I'm sorry, on 27/10/2025 at 2 p.m. while playing in the government middle school premises of Ketum Fieldwang, while climbing onto the roof of the school, accidentally came in contact with the low-hanging electric wire, which was hanging just about 3 feet above the roof. Stop. As a result, he suffered electric shock and he was taken to the district hospital in Serchhip, from where he was again referred to Zoram Medical College and Hospital, bracket ZMCH, and was given treatment in the ICU. So, as per the assessment of the medical officer, the petitioner has been classified to have suffered grievous injury. So, the learned senior counsel, referring to the injury report dated 27/10/2025, submits that the petitioner has been said to have suffered electric burn injury around 45-50% of total body surface area, and the injury sustained by him was grievous, severe, and required ICU admission. Stop. He submits that although the petitioner has been since discharged from the hospital, but he has suffered. No, he continues to suffer because of the burn injury, and which has also made him permanently disabled to some extent. Stop. The learned senior counsel submits that the petitioner's family belong to the petitioner's family are very poor and cannot afford further appropriate treatment. And therefore, they had approached the Power and Electricity Department for payment of compensation. Of the petitioner and his family were informed that with the kind of injury suffered by the petitioner, he may be entitled to a sum of rupees 5 lakhs. As ex gratia compensation, which is notified by the government of Mizoram in the Power and Electricity Department. In the Mizoram Gazette dated 16/4/2021. So the family of the petitioner was therefore advised to submit a consent affidavit in order to get the ex gratia compensation. Stop. Although the petitioner submitted the same, but the amount has been denied to him. Stop. Having no alternative, the petitioner is before this court. Stop. On a pointed query by this court as to whether the petitioner has obtained a permanent disability certificate from the competent authority, the learned senior counsel submits that in view of the hardship faced by the petitioner and his family, they are not in a position to approach the appropriate authority for grant of such disability certificate. Next para, considering in view of above, issue notice of motion returnable by 4 weeks. Ms. Vanessiami, learned government advocate, accepts notice on behalf of
1 to 6.
all the respondents, and therefore no formal notice is required. Petitioner shall serve requisite extra copies of the writ petition to the learned government advocate within 2 days, if not already done. Pending consideration of the writ petition, the petitioner would be at liberty to approach the competent authority for issuance of a permanent disability certificate. Stop. It is also made clear that in the event the petitioner approaches such authority in the manner that has been prescribed, the competent authority shall extend all support for issuance of such certificate. List again after 4 weeks.
Obliged.
From orders list, item number 11.
I appreciate Lordship.
Your Lordship, as per the last court's order dated 9/6/2026, I was supposed to take instructions from the Kala, and I have received the instructions today, and I have produced the instructions to Your Lordship as well. Now, Your Lordship, the instruction received is that Kala has not arbitrarily altered the award approved by the Government of India. The award was originally prepared on the basis of survey data, which erroneously indicated that the petitioner's land fell within the right of way. The petitioner herein is the respondent number 12 in the IA. IA is for implement of parties, the applicant, sealer in Chani.
Implement of parties
Yes, Your Lordship.
in the writ petition.
Yes.
You're for the applicant.
I
Mr.
am
Zamfar.
for the applicant, my lord.
Why do you want to be implemented?
I want to be implemented because the construction of the road has affected my land. However, my name has not been reflected in the award, and in the connected writ petition, the petitioners is claiming for disbursement of the award, the money which was supposed to be paid to for my land. So Kala has erroneously included the name of the respondent number 12, Zhou Ming Tangi, instead of my name. And Kala has made a resurvey wherein it has been indicated that my land would be affected and the land of the respondent number 12 would not be affected. So this is also part of the clarification, my lord.
So if you get yourself impleaded, ultimately,
Ultimately, yes.
and what would be the relief which is admissible to you?
No, my lord.
You'll defend yourself, that's all.
My lord, yes.
Can you demand something?
No, my lord.
You will just defend yourself.
Let me clarify, my lord. I want to be impleaded because I want, first, I want to receive the affidavit filed by the Kala. And thereafter, if the affidavit filed by the Kala indicates that I am entitled to compensation, then I will file a fresh writ petition. So that is why I want to be impleaded in the first place.
You can file a writ petition fresh separately.
Yes, my lord. But without the report of the Kala, nothing is certain at this stage. Because without the report of the Kala, nothing is certain. Now, since Kala has given a report, I can file a fresh writ petition on the basis of this, my lord.
So what, you want to withdraw this IA then? To file a fresh writ petition?
Yes, my lord, that also I can do.
Because IA, you will file, you will object, you will counter
I
object. This will go on and on and on. Nothing will happen. But if you file a writ petition,
Yes, my lord.
it will stand on its own feet.
Yes, my lord.
You will challenge something and also pray for some relief.
Yes, my lord.
Now, if your IA is allowed, you will just be merely a respondent there only.
Yes, my lord. But to appraise the court, the factual scenario of the case, my lord.
So I think the simplest way will be for you to file a writ petition on your own.
Yes. And
Make whoever a party
Yes.
necessary to be made.
yes, my lord. But this report also is not very clear, my lord. So if they can clarify this, then I'll withdraw the IA.
No, how can you seek for clarification like that? You're not even a party at this stage. It's only
Yes,
an
my lord.
application.
I'm not a party. But my lord, in the previous court date has indicated that this IA will be taken up only after a report has been given in the connected writ petition by the Kala. And now Kala has given a report. And somehow they have stated comments in court order IA number 228 of 2025, whereas your lordship indicated that a report should be given in WPC number 128 of 2025. So if this report stands corrected, then I can withdraw the IA and file a fresh writ appeal, my lord. A writ petition, my lord. Because going through the report, my lord, it is very clear that his name, the name of Zhou Ming Tangi has been erroneously inserted. And Kala has withheld the compensation due to that reason, my lord.
So initially it was thought it fell within the right of way.
Yes, my lord.
Now they say that it does not fall within the right of way.
Yes, my lord.
So the petitioner will not be entitled.
Petitioner would not be entitled. And my lord, the question of locus standi is also in issue in the connected writ petition. Because Lalram Siami is the writ petitioner in the connected writ petition, whereas she claimed that the respondent number 12 have gifted her the said landed property. Respondent number 12 is the real actual owner of the land. However, there was no registered gift deed or anything in favor of Lalram Siami. That also I would challenge in the writ petition if I am impleaded, my lord.
Mr. Benjamin, what have you challenged here? The decision taken by the
Maybe,
Kala.
My Lord, in the main writ petition,
Uh,
as my learned friend had already highlighted, mentioned, I was claiming for the compensation which was already determined.
But it has not been paid to you. It has
Exactly,
been
my
withheld.
Lord. It is for
That is
the-
why you have come.
Exactly, my
Okay.
Lord. So, my Lord, this case is not a question of overlapping of land. That is number one. And number two, why not claiming his own separate share? Why claiming from my share? That is number two. And number three is that, my Lord, under the NH Act, National Highway Act, my Lord, in the 3A, 3D, 3C, and 3G notification, I was there, my Lord. So, in my main writ petition also, I have annexed the one judgment of the Honorable High Court, my Lord, WPC 106 of 2021, my Lord. This is Tilaram Chuani, wherein Your Honorable Lordship had held that once the 3G award has been passed, my Lord, it cannot, the Kala or the competent authority, they does not have the authority to tinker with it in any manner whatsoever. So, and number four is that, my Lord, this award has not been challenged yet, my Lord. So it still stands, my Lord. The 3G award. That is another point. And number five is that, my Lord, in the IA, we can see that, my Lord, the survey and the verification, etc., they were all conducted behind the back of the instant petitioner in the main petition, my Lord. We were never notified nor given an opportunity to object or contest, my Lord. That is another point. And since my learned friend was relying on the comments made by the Kala, my Lord, I would like to submit that we have just received the comments today, my Lord, so I have just gone through it.
Kala is a party.
Kala is a party in the
Respond
IA,
number
my
six.
Lord.
6
7.
in the writ petition. Writ petition, it's 6. Additional Deputy Commissioner, Competent Authority for Land Acquisition.
Number 6, my Lord.
Number 6. You have not filed affidavit in the main writ petition. You are representing respondent number 6.
Yes, Your Lordship, just recently.
You have filed your power, you are representing. So why don't you file your affidavit?
In the main writ petition.
Yes. And in the IA also you may file.
So, my Lord, one more, if I
In
may.
the IA also you are a party, isn't it?
Yes, Your Lordship.
But IA is for impleadment only.
Only,
This is only for impleadment. Now, main writ petition is that award is made. Why haven't you not given me the award?
so, my Lord, my
Compensation.
main point is that there is no reason to impede the applicant in the main writ petition, my Lord.
Because, my lord, we will be raising the question of
There is no question of
there is
overlapping,
question
my
of
lord.
maintainability. Because if your lordship may turn to page 31 of the writ petition, my lord.
See, amendment, impleadment or no impleadment, whatever it may be, Mr. Benjamin, ultimately the comments of the Kala will have to be considered. He says that your land initially, there was a wrong impression that it fell within the right of way. When a resurvey was done, it was found that you don't fall in the right of way. Hence, there was no question of paying you the compensation.
My Lord, kindly, if you could come to
So there's no point in going on this issue at this stage. You
my
see,
Lord, kindly come to page number 21 of the IA.
No,
kindly,
21
my
is for
lord.
impleadment. See, IA is for impleadment. That I understand.
My Lord, in the annexure, in page number 21, if you could kindly,
See, even if you
For
don't
you, see.
implead, if you don't implead the applicant also, you still might not get the relief. This is what I'm saying.
my Lord,
Because
I get
assessment
the
was
point,
made
my Lord.
on the wrong notion that you are affected. Later on, it was found that you are not affected.
No, my Lord,
Despite the finding that you are not affected, should you be given compensation?
In that regard, my
That is
lord,
the issue.
kindly come to page number 21 of the
That is
IA, my lord.
why, that is why I would ask the Kala to file an affidavit in the main writ
Exactly, my
petition.
lord.
You can respond to that. And this comments will not do. Apart from these comments, you'll have to show us what is this resurvey. When was this resurvey done? Who did the resurvey? And what was the purpose? That you have to justify. Otherwise, tomorrow again you will say, no, this was wrong. Again, we do one more resurvey. And you'll take out somebody, put in there somebody else again. This cannot happen again and again, you see. There could be a genuine mistake, but one cannot go to that extent that you completely fail to notice that this person's land is not affected at all. So this speaks about what kind of survey was done.
My lord. My lord, in page number 21, the alignment is there. It's
It could
still
have
there in
been a
my
table
land, my
survey
lord.
also. You know, table survey, table reading. The surveyors go to the plot. They say, it's very vast. We have seen it. And they'll go back in the office and they'll just prepare in the table and say, this is what we have done. They don't go physically to the place to verify. This happens. That's why all this mistake is happening.
Yes, my lord. And my lord, in the meantime, if I may be pleaded just to raise the question of maintainability of the writ petition, my lord. Because she is not, the petitioner is not even the landowner.
See, I told you already, instead of pleading yourself, you file a separate writ petition.
No, my lord, I want this writ petition to be dismissed on the ground of maintainability because she's not even a owner of the land. She's not even a landowner. How can
See,
he
for that,
come?
you may not have to be impleaded also.
But
May
that
not have to
could-
be impleaded
yes.
also because seeing the survey, seeing the kind of comments received from the Kala has said that they have made some mistake.
Yes, my lord.
He was not affected by the land, the construction of road. That is why resurvey was done and found and accordingly not given to him. But this is only a paper. Let her file an affidavit.
Yes, my lord.
My lord, apart from that, the question of impleading, when it comes to question of impleading in the main writ petition, there is no question, my lord. This is not a case of overlapping, my lord. He can claim a separate claim, my lord. There's no question of impleading the instant applicant, my lord, in the main writ petition.
My lord, why are,
And
they,
apart
so,
from-
why are they so afraid of my impleadment? I don't know.
Apart from that, my lord,
It's not a case of overlapping. I don't
Exactly,
think
my lord.
Nobody's saying overlapping.
exactly.
And this instruction of the comments given by the Kala also shows that. It doesn't say that there was overlapping between two lands. It just says that
Exactly, my lord.
the petitioner's land was wrongly thought to be affected by the ROW. But later on, after resurvey, it appears that ROW does not affect his land.
And
That
my
is
lord,
why we have withheld the payment.
in 21, there is the resurvey. Alignment is there, and my land is still there, my lord.
21 of the IA.
Yes, exactly, my lord. 21. Page number 21 of the IA, submitted by my learned friend, my lord. The comments submitted by the Kala and the alignment does not match again, my lord. Zoming Tangi is there, my lord, in the alignment.
My lord, this is exactly why her name has been wrongly included in the award. Every assessment, everything has been done over my land. My land is the right side, is the left side. Zhou Mingtang's side is clearly indicated. Somehow she Google pinpoint or I don't know.
No, but
Her name.
how do we read this page 21? Zhou Mingtang's site is there.
Zhou Mingtang's side is there. The other side is Zauram Liana. That is my late husband.
And my lord, if you could kindly see the alignment, it's within the alignment, and this is the survey reconducted by the Kala, my lord.
Somehow they inserted their name
And
over my land. That
No,
is
no,
the reason
my
why
lord.
their name is included in the award.
this is after the resurvey, my lord. So this is the final survey, what I meant to say.
Even
sir.
the comments
this is
in
the
the
final survey, my lord.
Even the comments in the bold letter, the last sentence in vernacular indicated that Rizawming Tangiram hi 4-lane alignment pon ani eh. They have no
Zoming Thang-
locus, my lord.
Zoming Thang is the petitioner.
Zhou Mingtang is the actual landowner.
Is the petitioner, yes, the landowner,
Petitioner.
my lord.
And the applicant in IA, who is it? What is the name?
Applicant is Sealer and Chani, the wife of Zoram Liana.
Zoram Liana. So this dotted lines,
Yes, this is the alignment.
this is
my
the
lord.
road.
Yes, my lord.
This is the ROW,
Yes, my lord.
the dotted lines.
Dotted lines.
And we see Zoram Liana's name also there.
Zoram Liana's, this is his land. There is, it's not very clear, but
And below that, Zoming Thang is also there.
yes, my lord. That is the reason why they got reflected in the award. They somehow inserted their name within our land, my lord. Within my land.
No, my lord, this is the duty report and an extra. This is 17 July 2025.
If your lordship may kindly see, Zhou
See,
Mingtang's site.
I don't think we can decide the issue like that
Yes,
yeah,
my
by seeing the map and this,
Yes,
that,
yes,
what is
Exactly,
what.
my lord.
We are not the expert in this. Now, Zoram Liana's name is there, and below that Zoming Thangi. And on the right hand side, again Zoming Thangi
Yes. This
Land.
is our actual land.
site. It starts from here.
Yes, my lord. They somehow inserted their name within our land. That
Who has
how
prepared
Kala
this
is
map?
practiced.
What is this map?
This is made on the basis of a resurvey, my lord.
Huh?
This is made on the basis of a resurvey.
Where's the beginning? Resurvey page 21, just like that.
No, my lord.
It's a part of which document? Page 21.
Page 13, my lord. Page 13.
Hmm?
Uh,
We are looking at the IA.
yes, my lord.
So page 21 is a part of which document?
Page 21 is a part of page 14, my lord. Page 14.
14.
Yes.
Duty report.
Yes, my lord.
My lord, 3G award in the main case was published on 30/4/2025, my lord. So
See-
this is subsequent to the publish of the 3G award, my lord. So this is the newest one,
3G reports includes your name, correct?
my lord.
Now this page 14 is after the 3G award.
My lord, 3G award was published on 30/4/2025. This page 14 is dated 17 July 2025.
Correct.
This is the resurvey, my lord.
Resurvey. So on resurvey, it seems
My land is
that
there in the alignment.
doesn't say so. You are Zoram.
It's in page number 21, my lord. We can see it from clearly in the alignment.
No, not 21 is nothing else. You see, the pata number so and so was measured as per so and so. GPS data shows that Srimati Zoming Thange's P pata is outside the alignment of Aizawl bypass. You are Zoming Thang, isn't it?
My lord.
So the report says you are outside.
But based on the page 21, the map, the alignment area, my lord, this is
We
within
don't
my
know,
land,
you
my
see,
lord.
we
My
cannot
name is-
transcribe the map. We go by what the report says.
Everything can be remanded back to the Kala and let Kala take a decision, my lord, in this regard.
No, my lord, after the passing of the 3G, they do not have the power, my lord, to alter the award, my lord.
That is in the
It's a
writ
settled law.
petition. IA is for implement or not implement, that's all.
My lord.
In the meantime, some instruction has come from Kala. Mr. Zoram Sana, you already have this report in your favor.
Yes, my lord.
What are you waiting for to file a separate writ petition? How can you say that let them clarify first, then I'll file writ petition?
Let them,
Supposing we reject your implement application, then what do you do?
the liberty will still be there, my lord, as per my humble opinion.
No, correct. So you should have thought of that in the first place, I think.
Because Kala is not sure of where he stands at the time of filing my application for implement. So now Kala has taken a decision. But one thing, my lord, I wanted to be implemented because I wanted to raise the maintainability of the writ petition, my lord. Because the petitioner is Lalram Siami in the writ petition. She is not even a landowner. How can she come to this court? Where is her locus standi? That question have not been put forward by the other respondents.
That will be subject to you being impleaded.
Yes, that is why I want to be impleaded, my lord.
If you are not impleaded, then you cannot say anything.
Yes, that is the reason why I want to be impleaded, my lord.
My lord, with regard to the issue raised by my learned friend, since he raised before your number, annexure number 3 in the main petition, page number 31, is the deed of gift. However, my lord,
No, we're not traveling anything beyond that. Now, I'll just see that this instruction has to be filed. Okay, at this stage. You all figure out what to do. In terms of the last court's order, Ms. Caroline K. Lumorpi, learned government advocate, presenting the Kala ISO bracket respondent number?
Number 7 in the IA.
7 in the IA has produced the comments of the said authority, which states that the award was originally prepared on the basis of survey data, which erroneously indicated that the petitioner's land fell within the right of way. Stop. However, after a resurvey was done, it was established that the petitioner's land fell outside the right of way. And that the resurvey does not amount to modification of the award. But only to verify the factual position. So therefore, the Kala is not in a position to disburse the amount solely on the basis of the reflection of the name of the petitioner in the award. Next para, in view of the above instruction, the respondent, Kala, shall file an affidavit in the IA as well as in the amended petition. Indicating the stand taken along with supporting documents within 2 weeks. Correct? List again on so and so.
Obliged, my lord.
2 weeks. 3rd of August.
Item number 12.
Yes, Your Lordship. I'm sorry to mention that I did not receive the case diary yet. So if this matter may be listed day after tomorrow, Thursday,
Case diary will come from where?
from Aizol.
Sorry?
From Aizol,
Aizol.
yes.
Okay, Ms. Vanessiami, learned additional PP, praised for and is given further 2 days' time to produce the case diary. List again on Thursday. Please give the date.
Deeply obliged.
Obliged.
Item 13.
13. Okay. What is this?
Please, Your Lordship.
Third party.
Third party appeal.
Appeal. Leave. Can we do one thing? Can we just take a break for 5 minutes and come back? Because it's going to take some time. Almost 12, that's why. Okay. Yes.
May I please, Your Lordship? My Lord, this IA is an application filed under section 151 of CPC for granting leave of the court for filing appeal against the impugn order and dated 25/9/2023, passed by the Learned Civil Judge Senior Division 3 Aizol in civil suit number 40 of 2023. My Lord, the applicant purchased one RCC building on December 12, 2022, which is covered under LSC number 1025/12/01/514 of 2005, which he purchased from the opposite party number 2 herein. However, without the knowledge of the applicant, the building purchased by the applicant seems to be ordered and decreed in favor of the opposite party number 1 in the impugn order. A copy of the impugn order and decree is at Annex 1 and 2. That the applicant gained knowledge of such proceedings in the last part of March 2024, after when the opposite party number 1, who is the decree holder in civil suit number 40 of 2023, filed and pursued execution case number 16 of 2024. By believing good faith that his case is nothing for the trial court, which the parties never disclosed during trial, the applicant filed review petition number 9 of 2024, praying to review of the order and decree dated 25/9/2023, and for retry of the case by inviting or allowing him to implead him as a party to the suit, and also giving chance to submit written statement. However, the review petition was dismissed on 26/9/2024. The review order is at Annex 3. Page number 17 to 21. The applicant, Srila Travella, on being aggrieved by the said order and decree dated 25/9/2023, files the connected appeal against the same before this honorable court. However, since the applicant was not a party in the civil suit number 40 of 2023, he needs to grant leave of the court to file the connected appeal, and hence this application. My Lord, if I may take your lordship to Annex 3, the review order at page number 17.
Yes.
My brief submission before the Learned Review Court is highlighted at number 3 at page 18. Learned Counsel for the review petitioner had submitted that the review petitioner had purchased one RCC building along with LSC number so-and-so from the hands of the respondent number 2 on 12/12/2022 at a considerable amount of rupees 50 lakhs, and out of which he made payment of rupees 35 lakhs. Since the original LSC was not handed over to him, it was agreed that mutation or partition shall be done in his name by the respondent number 2, and balance payment will be made in due course. Thus, prayed for review of the order and decree dated 25 September 2000. This is typing mistake. It should be 2023. In civil suit number 40 of 2023 on the following grounds. Number 1, ordered the impugn order dated 25/9/2023 is passed without any proof that the two RCC buildings are located within LSC number 796 of 2008 purchased by the plaintiff. In fact, the land, namely LSC number 796 of 2008, purchased by the plaintiff from the defendant, seemed to be vacant land. As such, the total value of the land as per certificate of land valuation is rupees 2,87,260 only. Hence, declaring the plaintiff of ownership over the two buildings located outside LSC number 796 of 2008 is not proper and liable to be reviewed. Number 2, for that, beside the defendant number 1, there is one other defendant, namely Keval Nakriati, whose version is very much required for deciding the present issue. In fact, the said two buildings are located within LSC number so-and-so, belonging to the defendant number 2. One of the building along with LSC number so-and-so was already purchased by the review petitioner, and he is now in actual possession. Hence, for proper determination of such factual position, the order and decree dated 25/9/2023 need to be reviewed. For that, there can be no valid agreement between the plaintiff and the defendant number one. The so-called compromise agreement was not executed in tripartite. Hence, the order dated 25 September 2023, based on an agreement executed between the plaintiff and defendant number one, cannot be valid beyond a repayment of money amounting to rupees 1 crore. Your Lordship, the learned review court dismissed this review petition on the ground that sale was made by the OP number 2 herein. However, the landed property was registered in the name of the OP number 3 herein. Only for that reason, the review court had dismissed my review petition. If I may take your
Who is
Lordship,
OP number 2? Who is OP number 3?
OP number 2 is the defendant number 1 in the main suit. The OP number 1 herein is the plaintiff.
No, OP number 2 is the person from whom you have purchased the land.
Yes, my lord.
And who is number 3?
Number 3 is the registered owner. The LSC was registered in the name of the OP number 3.
So you purchased the land from OP number 2,
Yes, my lord.
although the name of the registered owner is OP number 3.
Yes, yes, my lord.
You know that.
Yes, my lord.
You knew that fact while purchasing the land.
Yes, I was assured that the partition will be done by the OP number 2.
No, on what basis the OP number 2 has sold the land to you?
Because the land belongs to her. Only
How? She's not the registered owner.
but she was in actual possession of the landed property.
Possession, how? I mean, like, is there any relationship between the OP number 2 and 3?
Not that I know of, Your Lordship.
They're different in person, not relatives.
The applicant also communicated verbally the OP number 3, and she disclosed that she had no interest in the land as she had sold to the OP number 2.
3 had sold to number 2.
Yes, my lord.
2 had sold to you.
Yes, my lord.
Then what was the dispute in the civil suit?
Your Lordship,
Who has filed the civil suit?
there is the OP number 1. The order is at Annex 01, page 7. The main prayer of the plaintiff, the OP number 1 herein, is at number 1.
No. Who is this plaintiff in the civil suit? What is her claim?
Maybe the OP number 2 has borrowed money from the OP number 1, the plaintiff.
It's not clear or what? Why do you say maybe?
I was not the party to the suit. If I may read, Your Lordship.
You are not a party, but at least you must have read this judgment. It must be there. Something must be there.
Yes, based on the judgment, yes. Yes. Decree was drawn
Before considering whether leave should be granted to you or not, at least the background has to be clear to the court, isn't it?
Yes, my lord.
So our court would like to know what is this civil suit about. You are not a part in the civil suit.
If I may read the order.
Yes.
This is page number 7, Annex 01. This is civil suit number 40 of 2023, filed by the plaintiff for declaring that the two RCC buildings and the land covered by LSC number 796 of 2008 are belong to the plaintiff by virtue of registration certificate dated 10/6/2022 in sale deed bearing document registration number 2223/.
Okay, just pause there for a moment. It talks about two RCC buildings.
Yes, my lord.
And it also talks about LSC of 2008.
Yes, my lord.
You have purchased LSC of 2005.
Yes, my lord.
So there are two different LSCs.
Two different LSC. But the plaintiff in the civil suit claimed that the LSC, the RCC building standing within my land should belong to her.
One building,
2 buildings, 2 RCC.
but in the review, you say that you claim you purchased one RCC building.
Only one, yes. The OP number 2 has made 3 plots in the LSC.
No, what is your claim? What is your case? You purchased the LSC of
Yes.
2005
2005, yes.
along with one RCC building.
Yes, yes.
In the civil suit, it was 2 RCC building and one LSC, which is name is different, registration number is different.
No, my lord, I have bought only some portion of the land,
Some portion of which land?
2005 LSC.
I see.
The 2005 LSC was separated in three plots.
Okay.
I have bought
What are
them.
those? You have purchased the land in the year 2022, December.
Yes, my lord.
Civil suit is filed in the year 2023.
Yes.
So you should have been a party here also, correct?
Yes, my lord.
So if you were a party, what would be your claim in that civil suit?
That the land, the property belonged to me.
Which property?
The RCC building, which I am now in actual position.
This civil suit judgment order speaks about 2 RCC buildings.
2 RCC buildings. One is
You're
mine.
claiming only one.
Yes, my lord.
Okay. So far RCC buildings concerned, okay, out of
Yes.
2, one is mine. Then what about the LSC? This is 2008. You had purchased 2005.
Yes.
2005 LSC was divided into 3 plots,
Three plots, yes.
including this 2008.
Yes. I don't know about 2008. 2008 is at another location.
If that is in another location, then there is no requirement for you to be a party. Of course, your claim is for one of the RCC buildings.
But, Your Lordship, in the order and in the said order and decree, my LSC was, my property was affected.
Where is that? So, where is it written?
If I may take Your Lordship,
There's some compromise agreement.
yes, compromise, based on the compromise. This so-called compromise agreement was also not executed in tripartite. It was executed between the plaintiff and the defendant. That is the OP number 1 and OP number 2. And based on this compromise agreement, order was made and decree was drawn at page 11, number 3 of the impugn order. If I may read, Your Lordship.
No, not reading will not help. You see, you must have read it earlier. What is the claim of this plaintiff, Rameng Zwali?
The claim of the plaintiff is that if the OP number 1 had not repaid the borrowed amount of money, the RCC buildings would belong to her. She would take the RCC building,
Okay.
which is not located within the LSC 2005 LSC, which is not located within the 2008 LSC.
Which is located
The
within.
LSC are actually located within 2005 LSC. 2008 LSC already belonged to the OP number 1. It was already mutated in her name before filing the suit. The OP number 1 had filed suit against the OP number 2 after she had already mutated 2008 LSC into her name.
Okay, you read the order. Let's see. It's difficult to make out.
Based
what
on
is
the
what.
compromise agreement dated 6 September 2023,
No, from where are you reading?
page number 11. my lord.
You read from page 7.
Page 7.
This is a civil suit from there. Let us see.
This is civil suit number 40 of 2023 filed by the plaintiff for declaring that the two RCC buildings and the land covered by LSC number 796 of 2008 are belong to the plaintiff by virtue of registration certificate dated 10/6/2022 in sale deed bearing document registration number 2223 SZL 011398. Also for declaring the RCC building occupied by the defendant number 1 and its adjacent RCC building are belonging to the plaintiff as both the plaintiff and the defendant number 1 executed Wisapuk Chungchang in Remna dated 25/3/2022. Also for declaring that the RCC building occupied by the defendant number 1 and its adjacent RCC building located at Segbok Ngaisel, Aizol are belonging to the plaintiff if such two buildings are not covered by LSC number 796 of 2008. Also for eviction of the defendant number 1 and her family from the RCC building presently occupied by them located at Segbok Ngaisel, Aizol. Also for directing the defendant number 1 and her family to shift away from the RCC building presently occupied by them, which is covered by LSC number 796 of 2008, located at Ngaisel, Aizol. Also for declaring the defendants not to relocate the area of LSC number 1025/12/01/514 of 2005, thereby shift into the area of LSC number 796 of 2008, located at Segbok Ngaisel, Aizol, as LSC number 796 of 2008 is belonging to the plaintiff. Also for a permanent and perpetual injunction against the defendants not to sell or to do anything which detrimental the interests of the plaintiff in respect of the RCC building occupied by the defendant number 1, RCC building adjacent to the RCC building occupied by defendant number 1, and LSC number 796 of 2008, located at Segbok Ngaisel, Aizol. Whilst proceeding with the case at the stage of filing of written statement, received a compromise agreement dated 6 September 2023 on 6/9/2023, which is reproduced as under in toto. The English translation is at annex page 9A. The undersigned parties made the agreement with respect to civil suit number 40 of 2023 as follows. Number 1, the amount of rupees 140 lakhs as per the agreement dated 4/7/2022 between Ramang Zoli and Siliam Kumis shall be reduced. Mrs. Ramang Zoli and Siliam Kumis borrowed cash amount of rupees 96 lakhs, along with interest, has not been repaid by Siliam Kumi for a period of 1 year and 2 months, and she will repay rupees 100 lakhs. Out of these 100 lakhs, Ms. Lian Kumi shall pay 50 lakhs to Ramngai Suwali. Before the expiry of 6 months, September 2022 to February 2024 from the court agreement. During this period, Mrs. Ramang Zoli shall not lock the two residential house of Sil and Kumi. However, if rupees 50 lakhs is not repaid before the expiry of February 2024, Mrs. Ramang Zoli shall lock the two residential house of Sil and Kumi, the building where she is currently residing and the adjacent building where she used to live. Checkbook. Immediately, execution case shall be filed. Mrs. Lian Kumi proved before court that at the building adjacent to the residential building of Mrs. Lian Kumi, Checkbook lived a family, but the said Miss Lian Kumi did not sell the said building to that family. They did not intend to possess in lieu of that, but reside in the said building as they are their relatives. At page 10A. The remaining 50 lakhs shall be paid to Mrs. Ramang Zoli before the expiry of 6 months, February 2024 to August 2024 by Mrs. Lian Kumi. After the money is repaid in full, the two residential buildings of Mrs. Lian Kumi and LLC number 796 of 2008 presently registered in the name of Mrs. Ramang Zoli shall be mutated into the name of Mrs. Lian Kumi. Mrs. Ramang Zoli shall assist as and when required. However, unless achieving as per the agreement above mentioned, the two residential buildings of Mrs. Lian Kumi, building where she Lian Kumi presently live, and the adjacent building where she used to live, located at Checkbook and its properties, and the LSC number 796 of 2008 shall not be transferred or sold whatever. if it is known that the said seal and Kumi has done what transfer or whatsoever, execution case shall be filed. If Seal and Kumi cannot comply as above mentioned, the two residential buildings of Mrs. Lee and Kumi building where Seal and Kumi presently live and the adjacent building where she used to live, located at Checkbook and the LSC number 796 of 2008 shall be vacated by Mrs. Seal and Kumi. As Mrs. Ramang Zoli has the ownership, she will have the power to lock the two residential buildings of Mrs. Seal and Kumi Checkbook. And the said Mrs. Seal and Kumi shall not have any objection and execution case shall be filed. My Lord, I was mentioned at number 5 of this compromise agreement. Mrs. Lenkumi proved before court that at the building adjacent to the residential building of Mrs. Lenkumi Chekbukli, a family, but the said Mrs. Lenkumi did not sold the said building to that family. They did not intend to possess in lieu of that but reside in the said building as they are the relatives. And this compromise agreement was signed between the plaintiff, that is OP number 1, and defendant, that is OP number 2. And based on this compromise agreement at number 3, based on the compromise agreement dated 6 September 2023, the defendant number 1 shall make a payment of rupees 50 lakhs before the end of February 2024 to the plaintiff. During this period, the two buildings, that is new building being occupied by the defendant number 1 and another adjacent building where the defendant number 1 used to stay, located at Checkbook, shall not be locked by the plaintiff. In the event that the defendant number 1 could not make payment of the said rupees 50 lakhs to the plaintiff before the end of February 2024, the said two buildings shall be locked by the plaintiff and the plaintiff would be at liberty to file an execution case. The defendant number 1 shall make a payment of another rupees 50 lakhs before the end of August 2024 to the plaintiff. If the full payment is made by defendant number 1, the said two buildings and the LSC number 796 of 2008 being registered in the name of the plaintiff shall get changed in the name of defendant number 1, and the plaintiff shall render assistance in this regard. If the full payment could not be made by defendant number 1 as per the agreement, the said two buildings and all the properties being kept in the said buildings and the LSC number 796 of 2008 shall remain untouched, and they shall not be disposed of. If the defendant number 1 violated the above, the plaintiff would be at liberty to file an execution case. If the defendant number 1 could not make a payment as stated above, the said two buildings and the LSC number 796 of 2008 shall be left by the defendant number 1, shall become the properties of the plaintiff. If it is necessary, the plaintiff will be at liberty to file an execution case. So, Your Lordship, this order affected my property, which I am now in actual possession. So, if I'm not granted leave to file the connected appeal, I will suffer an irreparable loss, Your Lordship. This application is filed for the interest of justice and allowing the application to not prejudice the parties. Your Lordship, if Your Lordship allow me, in support of my submission, my prayer, I bring two authorities.
You file an appeal against what, the review order?
No, my lord.
Where's
The main judgment, yes. The order.
The LSE was in the name of respondent number 3,
Respondent number 3, yes, my lord.
and it was respondent number 2 who sold the land to you.
Yes, my lord.
So he did not have the power to sell the land when he himself does not own the land. This is the finding of the review court.
But your lordship, the compromise agreement was also executed between the plaintiff and the defendant. That is the OP number 1 and 2. The OP number 3, the registered owner of the land was not in the compromise agreement. Was not made a party.
OP number 3 is the registered owner.
Yes. At page number 10 of Annex 10, yes, Annex 1.
In the civil suit, what do you mean OP number 3? In the review petition, defendant number 2,
In the civil suit, page number 10, at Annex 1, my lord. The compromise agreement,
it is between
plaintiff is the OP number 1 hearing, defendant is the OP number 2 hearing.
is between the plaintiff and the defendant number 1.
Yes, my lord.
Defendant number 2 is not in the picture,
Yes, my lord.
although she is the registered owner.
Yes.
But no relief is claimed against the defendant number 2, isn't it?
Yes, my lord.
No relief is claimed.
Although it was registered in the name of the defendant number 2, relief was claimed against the defendant number 1, from whom I bought my LSC.
You have purchased the land from Seal and Kumi,
Seal and Kumi, yes.
and Seal and Kumi had borrowed land from the plaintiff, borrowed money from the plaintiff.
Yes, my lord. That is the case.
See, what is the arrangement between the other parties? This is difficult to make out. Insofar as your case is concerned, you say that you have purchased the land. Offered price was 50 lakhs. You have given 35 lakhs already.
My lord, yes.
And this you have purchased from the different, the
OP number 2.
Huh?
OP number 2, yes.
OP number 2.
Yes, is the defendant in the main suit.
But OP number 2 did not have any registered land in her name. She was in possession of the land only.
Yes, he was in possession. And the building was also constructed by her.
By her. Now, what has happened to this compromise agreement? No one has challenged it. It's a compromise agreement, correct?
Yes, I am challenging this order.
Apart from you,
Yes,
the other two parties are going they're going by the compromise.
yes, my lord.
Okay. What is this authority? Citing?
Lordship, the principle laid out in the judgment done by this apex court in these two authorities. Number one is citation 2022 Life Law SC 698 at page number 7 and 8, my lord. Para number 29, 30, and 31. The page number is at the bottom of the page. Para number 29. May I read, Your Lordship? The respondents in the present case had access to recourse under section 96 of the CPC, which allows for appeals from the original decree. It must be remembered that the present matter was being heard by the High Court exercising its original jurisdiction. The High Court was in effect conducting a trial, and the final decree passed by the High Court on 99/2013 was in effect a decree in an original suit. As such, there existed a right of appeal under section 96 of the CPC for the respondents. Though they were not parties to the suit, they could have filed an appeal with the leave of the court as an affected party. Section 96 of the CPC read as under 96. Appeal from original decree, save where otherwise expressly provided in the body of this court or by any other law for the time being in force, an appeal shall lie from every decree passed by the court exercising original jurisdiction to the court authorized to hear appeals from the decisions of such court. An appeal may lie from an original decree passed ex parte. No appeal shall lie from a decree passed by the court with the consent of parties. No appeal shall lie except as a question of law from a decree in a suit of the nature cognizable by courts of small causes where the amount of value of the subject matter of the original suit doesn't exceed 10,000. Section 96 to 100 of CPC deals with the procedure for filing appeals from original decrees. A perusal of the above provision makes it clear that the provisions are silent about the category of persons who can prefer an appeal. But it is well settled legal position that a person who is affected by the judgment but is not a party to the suit can prefer an appeal with the leave of the court. The sine qua non for filing an appeal by a third party is that he must have been affected by reason of the judgment and decree which is sought to be impugned. In the light of the above, it can be safely concluded that any aggrieved party can prefer an appeal with the leave of the court. And number 2 is, my lord, 2025 INSC 121. At page number 23, 24, para number 43. The principles governing the grant of leave to appeal may be summarized as under. Section 96 and 100 of CPC respectively provide for preferring an appeal from an original decree or decree and appeal respectively. The said provisions do not enumerate the categories of persons who can file an appeal. However, it is a settled legal proposition that a stranger cannot be permitted to file an appeal in any proceedings unless he satisfies the court that he falls within the category of an aggrieved person. It is only where a judgment and decree prejudicially affects a person who is not a party to the proceedings he can prefer an appeal with the leave of the court. A person aggrieved to file an appeal must be one whose right is affected by reason of the judgment and decree suit to be impugned. The expression person aggrieved does not include a person who suffers from a psychological or an imaginary injury. It would be improper to grant leave to appeal to every person who may in some remote or indirect way be prejudicially affected by a decree or judgment, and ordinarily leave to appeal should be granted to persons who, though not parties to the proceedings, would be bound by the decree or judgment in that proceedings and who would be precluded from attacking its correctness in other proceedings.
So now tell us, how are you affected by this judgment?
Your Lordship, in the impugned order, my property was mentioned.
Where is that?
If the OP number 2 cannot repay the money to the OP number 1, my house will be locked.
Where is your property mentioned? Which part?
Page 11, my lord. Based on the compromise agreement dated 6 September 2023, the defendant number 1 shall make a payment of rupees 50 lakhs before the end of February 2024 to the plaintiff. During this period, the two buildings, new building being occupied by the defendant number 1 and another adjacent building where the defendant number 1 used to stay, located at Sekbok, shall not be locked by the plaintiff.
Just pause there.
This is,
This is the building.
yes, another adjacent building.
And another adjacent building where the defendant number 1 used to stay.
This is my building.
Your building in the sense that you have purchased it.
Yes, yes, my lord.
Shall not be locked.
Yes,
Subject to payment.
yes.
Then, in the
In
event,
the event that the defendant number 1 could not make payment of the said rupees 50 lakhs to the plaintiff before the end of February 2024, the said two buildings shall be locked. The said two buildings shall be locked by the plaintiff, and the plaintiff would be at liberty to file an execution case. The defendant number 1 shall make a payment of another rupees 50 lakhs before the end of August 2024 to the plaintiff. If the full payment is made by the defendant number 1, the said two buildings and the LSC number 796 of 2008 being registered in the name of the plaintiff shall get changed in the name of the defendant number 1, and the plaintiff shall render assistance in this regard. If the full payment could not be made by the defendant number 1 as per the agreement, the said two buildings and all the properties being kept in the said buildings and the LSC number 796 of 2008 shall remain untouched, and they shall not be disposed of. If the defendant number 1 violated the above, the plaintiff would be at liberty to file an execution case. If the defendant number 1 could not make a payment as stated above, the said two buildings and the LSC number 796 of 2008 shall be left by the defendant number 1 and shall become the properties of the plaintiff.
what is this? If he cannot pay, it will remain untouched and all that. What does it mean?
Not to dispose of.
It will not go to the plaintiff. It will just remain as it is like that.
Maybe.
What kind of arrangement is this? So anyway, you are affected by that adjacent building
Yes, ma'am.
where defendant number 1 used to stay.
Yes. Being a brief, I.
What about the LSC? The LSC is of 2008. Yours is of 2005.
2005, yes.
How is it
LSC of
connected?
2008 LSC was already registered in the name of the OP number 1. Already registered in the name of the OP number 1, 2008 LSC. But it seems to be a vacant land as the
What have you purchased? 2005 or 2008?
2005.
Correct. So how is it connected to 2008?
There is no connection, my lord.
Then
But however, in this suit, the plaintiff claimed the buildings which is within my landed property when she had ownership over the 2008 LSC. 2008 LSC. She claimed that the two LSCs are located.
these two
within
LSCs are separate.
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 LSC,
Number is also separate, so it's separate. Location also separate.
separate. Yes, my lord.
So there's no issue on the LSC. Only issue is in the building.
Building, yes, my lord.
One building which is located in the LSC 2008.
2005. The LSC, the buildings are located within 2005 LSC. Two buildings are there
Within 2005.
within 2005.
But
From
that is not mentioned in the judgment. It talks about the two buildings
two buildings. It
in-
is not mentioned, yes, my lord.
in LSC number 2008.
So, your lordship, in this case, without proving the actual location of the building, order was passed, which affect my building.
So the deal here is with regard to that LSC of 2008 and also two buildings
Two buildings, yes.
standing where?
2005.
In 2005.
Five, yes.
So you have nothing to say as regards LSE of 2008?
Yes, my lord.
Only that your building
Yes, my lord.
has been affected.
Exactly, my lord.
It just says building, like there's no other description of the property.
2008 building is a vacant land. Based on the land valuation certificate.
No, is there any building standing in 2008 LSE?
No, my lord.
Okay.
It is a vacant land.
So these two buildings, where are they standing?
Within 2005 LSC.
2005.
But it was ordered and decreed in favor of the plaintiff. We
Ah,
are
that's-
proving the actual location. Now execution case is pending and will be one building within 2005.
Or execution
under
case
law.
is pending.
Yes, yes, ma'am.
So that means the agreement or mutual agreement has not been honored.
May-
Obviously, that's why
Yes,
execution.
Yes, yes. I came to learn this fact when the plaintiff pursued the execution case.
What is this registration certificate dated 10/6/2022?
That is in connection with the 2008 LSC.
In sale
It was-
deed
it was-
bearing document
It
registration?
was already given to the OP number 1 by OP number 2.
Anyway, let me hear Mr. Tokomo. Please throw some light. We'll get back to you. Let me just ask him what is what.
My lord.
May it please, Your Lordship.
You're the plaintiff
I
in
am
the
the
civil suit.
plaintiff in this case. As my learned friend has stated that there are two LSCs involved. Number one is the 2008 LSC, which is registered in my name, already mutated in my name.
In your name?
In my name.
2008.
2008. That is in my name. Duly registered, duly mutated. So there's no dispute on that. Now, basically, although this is a civil suit, my main relief that I was seeking was for the return of the money. Now, the reason why we have implemented the present respondent number 3
No,
as
no, return of money means what did you do? You lend money to somebody?
I lent money to the present respondent number 2, who I rate as defendant number 1.
Seal and Kumi.
Yes. Celia and Kumi had taken money from me.
Okay.
So, to be very honest with this court, the reason why this 2008 was mutated in my name was because as a security. As soon as she returns my money, we will execute another sale deed, and it will be mutated back into her name. So that was the arrangement.
And
So-
how much was borrowed and it was to be repaid by what time?
6 months. My understanding is that, yeah. So that was not done. That's why I sent legal notice that was not replied. As such, I was forced to file the civil suit number 40 of 2023. Now, regarding this 2005 LSC, the only reason I have pleaded the registered owner of this 2005 is that I had come to learn from the revenue authorities that they were planning to, this is as per their submission in the plaint. This registered owner of this 2005 LSC was planning to shift the location into my LSC. That was their submission before the court. So that is the only reason why this registered owner of 2005 was impleaded. In fact, no particular relief was granted. Was prayed for.
Registered owner is that defendant number 2
Correct.
in the suit.
Correct. So the only limited relief that I sought against the respondent, the defendant number 2 was that this location should not be shifted into my LSC. That was done as abundant precaution. So in any event, during the course of the trial, at the time of submission of written statement, that particular compromise decree was drawn up.
Okay, before that, you see, what is that concept of transfer of location? One is
under-
2008, one is 2005.
Correct. So
So-
even I'm a bit hazy on that particular issue, but regardless, that is what was mentioned in the plate.
So if the location is transferred, then what happens to
It will overlap naturally.
5 will overlap 8.
That's what.
So 8 will disappear.
So although it seems very unlikely, we took abundant precaution. That's why we filed it. That's the only reason. In any event, that this 2005, as far as the 2005 LSC is concerned, we're not too concerned with that. So anyways, since my learned friend has already read out a compromise decree, I will not do the same. But if Your Lordship can turn to page 17 of that is the order passing the review petition. I believe Your Lordship has already read it. That
See, the LSC of 2008, does it have any building standing on it?
2008, as per my understanding, is vacant.
Vacant.
That's
And
as
where
per
are
my
those two
understanding.
buildings?
It's in this 2005 LSC.
2005.
Yes. Regarding that compromise decree, my learned friend has stated that only the plaintiff and the defendant number 1 had signed
No,
it.
no, we'll come to compromise later on.
Yes.
So 2008 registered in the name of
My name.
plaintiff.
Yes.
Is registered in your name.
In my name.
So there's no question of claiming whatever is already registered in your name.
Exactly.
But the judgment says that filed by the plaintiff for declaring that the two RCC buildings and the land covered by 2008 belongs to you by virtue of registration dated so and so and sale date so and so. So if it's already registered in your name, why are you claiming again by filing a civil suit?
No, I filed for declaration. I filed for declaration
Declaration.
that it is mine.
Then what about also for declaring the RCC building occupied by defendant number 1 and its adjacent RCC building belongs to the plaintiff, as both the plaintiff and defendant executed so and so. Then it comes again, it says also for declaring. This is another aspect.
I don't. Which part is Your Lordship referring
Page
to?
8, page 8.
Page 8.
Come to the third line, page 8. Also for declaring. Because of that in remna
In
dated.
Remna, yes. So in default, in case of default, these two buildings will become mine.
Also for declaring. Are if not covered by LSC
Not
number
covered
2.
by. If it is not covered, then I
These
should.
things are very uncertain, you see. You say at one point that it's not covered. I mean, the land is empty. Now there's no building. But again, the claim you say that if it is not covered by 2008, those are mine. Again.
Yes. There appears to be some gray area in the facts of the case. In any event, Your Lordship, as far as the compromise agreement.
See, although we are concerned with leave or no leave, but still at least some background is required. You see, we have to write an order.
I agree with that. On that particular issue, but as far as the compromise agreement is concerned, the counsel for the defendant number 2 had signed it. The defendant number 2 is the registered owner of the 2005 at page 10.
Anything mentioned about the role of defendant number 2?
Not really, my lord.
So the sum and substance is that the amount has been reduced to 1 CR.
Correct. That is the
And,
interest portion.
50% you pay, 50% later on.
Yes. So in the event of
Now,
default,
the applicant says that because of this agreement, one of your building has been taken over.
so regarding that, since we are on the leave application regarding that, although my learned friend, unfortunately, his client may have suffered some injury, no doubt. Possibilities are there as per the agreement and as per the new facts that have been thrown into light. But what is the legal right that has been infringed so far as he is concerned? In the review order, it clearly stated that an agreement of sale was executed between the applicant and the present respondent number 2, who is not the registered owner. So, in light of that, what would be his locus What rights of his has been infringed? Whether this compromise decree is right or correct or wrong, who is he to question it?
Compromise decree between the
Parties.
plaintiff and the defendant number 1.
And defendant number 2's counsel signed it.
And the applicant has purchased the land according to him
From the respondent number 2,
from the respondent number 2.
when the registered owner is the respondent number 3. So that is the reason that was given in by the review court
From the hands of respondent number 2.
at page 20, Your Lordship.
No. See, review petition is, judgment is at page 17.
Starts at page 17, relevant page is at 20,
And
paragraph 6.
no, the respondent number 2 in this review petition is Sealy and Comey, correct?
Correct,
And Sealy and Comey is the defendant number 1 in the same main suit,
correct,
civil suit.
correct,
According to the applicant,
correct.
he has purchased
The building,
land from this defendant number 1 in the suit.
correct. But unfortunately, that 2008 LSC, 2005 LSC belongs to the defendant number 2. It was never hers to sell in the first place.
But if that is the case, then defendant number 1 could not have made an agreement to dispose of the building.
No, there's no question of disposal because as far as my rights are concerned, as far as that compromise decree is concerned, in the event of default, I only have the rights to, I have to file an execution case. So the court will consider that.
No, correct. But you are all fighting over the plot, a particular building,
I'm not fighting, he's fighting.
which, no, your civil suit says that you claim over a thing. In
Correct.
lieu of your money lent by you, you're claiming the property and the building
Correct. And that has been decided.
decided on the basis of a compromise agreement.
Correct.
But the building which is affected there, according to the applicant, was purchased by him along with the
So
LSC.
that is his submission. Please show me one legal document to prove that, in support of that. This is a court of record after all. You show me one piece of paper. That is his submission only. He has also not mentioned, there's no annexure, nothing. That is what I'm trying to say, Your Lordship. What rights of his has been infringed? What would be his locus standi?
So where is the review petition?
Review petition order is at page 17.
Not the order, on the basis on which review has been filed.
That has not been annexed by my lord.
Did you annex any document
Lordship,
of you paying 35 lakhs?
Your Lordship, I have annexed this review order as the facts has been highlighted in this, recorded in by the
No,
trial
apart
court.
from the review order, where is the review petition? Or can you clarify the fact that whether you have purchased the land by way of a right sale deed or any written agreement? That you're purchasing it by 50 lakhs, but you're paying 35 of now, as of now, remaining after the LSC is mutated in your name, which has been stated in the order. You have a copy of the review with you? Review petition.
Yes, my lord.
What have you annexed there?
The sale letter.
Sale letter.
Yes,
What does it say?
it's in a vernacular. Boy som panhi. Som panhi sang ni som hi panhi. Hian ka building LSC number 1025/12/01/514 of 2005. Ke vanlil triati minga plot number 108 na hi ulal thavela mol puine na cheng noi somnga in kashala cheng noi som thum panga kadong hala noi som panga balan somani a balance lom hi pension su huna in han pel turin kan in rem siamani aram then darle pulal travela minga LSC tura mala khichu silian khumi mo purna aniang.
Okay. So you have not annexed that in your application.
Yes, my lord.
Why?
Because
That is why Mr. Fakoma is saying that, see, on what basis you are claiming?
as it was disclosed, it was recorded by the review court. I thought it was not necessary to. If your lordship allow me to file it by way of additional affidavit, if it is required. My learned friend had annexed my petition without the annexures. I will file it with the annexures.
Okay, you file it then.
Yes, my lord.
Mr. Fakoma.
Well, that aspect is already recorded at page 20, para 6 in the review order. That is what I was trying to read out.
Page 20.
Page 20, para 6. I'll just read one paragraph, Your Lordship. May I read, Your Lordship? Heard the learned counsel in peruse the records of civil suit number 40 of 2023, wherein the order and decree dated 25/9/23 were passed and drawn. On perusal of the compromise agreement, it appears that the plaintiff, the defendant number 1, and the respective counsel, along with the counsel of defendant number 2, have appended their respective signatures to the compromise agreement. The alleged sale letter executed between the review petitioner and the respondent number 2 is also perused, wherein the respondent number 2 had clearly stated that LSC number so and so 515 of 2005 is registered in the name of the respondent number 3. It is a well-settled position of law that one cannot sell any property which he himself does not own. Therefore, the alleged sale of the building and LSC by the respondent number 2 to the review petitioner is invalid, as the respondent number 2 is not the registered owner of the said LSC. That is the reason why it was
No,
rejected.
you see, what is sold is not the LSC. I think it was, what is sold is the building.
Yes, building, plot 108.
What did you buy? The building.
Yes, the plot, the building and the plot. It was divided in 3 plots,
Correct.
the LSC.
So the LSC has not been
With
partitioned.
respect to the submission made by my learned friend, Your Lordship, may I submit this judgment?
And also that is not a
No,
registered
no,
document.
see, judgment will come later on. Let us be clear on the facts first, you see. What we have written here in the building in Lena
Yes,
is that you have bought the purchase the building.
yes. Plot number 108. Another LSC has to be drawn on that plot.
Plot number 108.
Yes.
How big is the LSC of 2005?
Your Lordship, the LSC was not in my position. It was in the position of the respondent number 2 at the time of buying the LSC. Bifurcation has to be done by her.
Anyway, we'll come back in the afternoon.
the order under challenge here was made on, based on the compromise agreement, wherein the seller was the party who made the compromise agreement. I'm the bona fide purchaser, so I'm protected under section 43 of the TPA.
But you are not against the order of review. You have not challenged the review order. You
Yes, my lord.
basically want a separate third-party appeal to be filed.
Yes, my lord.
Whatever review court has held, has been held. You have not challenged that.
Yes, my lord.
So even if the review fails, is there any bar for you to file an appeal?
No, my lord.
There's no bar. So then basically it's on the appeal only. We are not here to examine whether the review court have rightly dismissed your review petition or not. We are here to see whether any interest is available to you on the property in question so as to enable you to file a third-party appeal. All right. Mr. Fakoma, anything else?
Yes, my lord. Regarding, I have just one citation which I've given. In fact, my learned friend has read it out, but I'll just read out the operative portion.
Which one?
This is the 2025. I've given the SSC citation.
Party?
Parties are H. Anjanappa versus A. Prabhakar, 2025. The relevant paragraph is at para 43. My learned friend has read it out. So out here, para 43, your lordship has it. The principles governing the grant of leave to appeal may be summarized as under. I'll just skip to the relevant portion. Sub para 5, so Roman 5. A person aggrieved to file an appeal must be one whose right is affected by reason of the judgment and decree sought to be impugned. So he has to establish that because of this ABCD judgment and decree, this right has been infringed, that right has been infringed. That has to be established, number one. And at serial number 7, Roman 7, it would be improper to grant leave to appeal to every person who may in some remote or indirect way be prejudicially affected by a decree or judgment. So he may have been affected in some way, indirectly or remotely, but will that give rise to a rights of filing a third-party appeal? Unfortunately, your lordship, my learned friend has relied on one sale letter, which the review court has said that it's null and void, since the executor of that particular document was not the registered owner of the property that was in, which formed part of the subject matter. Number two is that since it's an immovable property, it is not a registered document. So without a compulsory registrable document, in the absence of that, will that give title and rights over the property to the applicant? Those are the things that I would like your lordship to kindly consider. Because unless those two aspects are established, in my humble opinion, although this particular compromise decree might remotely affect him, but the question is, what rights of his has been infringed? That he has to establish. And unfortunately, perusal of his application does not say anything on that respect.
You have filed your objection, right?
I've done.
What have you stated there?
I've basically stated that the subject matter in issue, which on the strength of which my learned friend is claiming that the 2008 LSC is not mentioned in the compromise agreement. Moreover, that particular agreement was executed in the presence of all the parties, including the registered owner of the 2005 LSC. And I have also mentioned that he has no locus standi. Whether he can said to be having a locus standi on the basis of an illegal and unlawful transaction. And that sale deed was also not enclosed, that I've mentioned as well. Or building in Lena, that document. So those are my humble submissions, Your Lordship. Because possession does not give you title, Your Lordship. In my objection, Your Lordship, at page 10, Annexure 1, that is the LSC 514 of 2005. The registered owners is reflected as K. Vandal Shetty. In my humble opinion, Your Lordship, if memory serves correct, my learned friend has stated that he had purchased a portion of the LSC. Unless and until that portion is partitioned and mutated in his name, in my humble opinion, as on today, he would not have any rights. Let him take all those recourse first, if what he's saying is correct. He has to execute another sale deed with the registered owner.
All right, we'll consider that.
My lord.
These aspects, we'll see. We'll post it again on Thursday.
My lord.
Please write, parties have made their rival submissions in the IA.
My lord, allow me to submit additional affidavit if it is required.
Additional affidavit for what?
Say later. My petition before the review court, along with its annexes. The petition has been annexed
It
by.
is here.
No, my lord, that is my copy actually. Just for your lordship's benefit, I just supplied it.
My lord.
Since my
although
learned friend was
I
reading
have,
from it.
Filed additional affidavit in IA number 177.
What is 177?
It is condonation application.
No, that is already done.
177 is disposed of, I think.
Yes, my lord.
So,
So, in this particular case, allow me to file the additional affidavit that is required.
additional affidavit, what do you want to file?
The say letter,
Sale letter.
yes.
Okay, you file.
My lord.
Stop. However, the learned counsel for the applicant, Mr.
Labik trauma.
Lalbi Aktuama, submits that he may be allowed to file the just the sale letter. What is the next year apart from that? The annexures appended to the review petition number 9 of 2024 filed by the applicant before the trial court concerned by way of an additional affidavit. Stop. Let the additional affidavit be filed by Friday,
By Friday, yes.
by 17th of July 2026. List the matter again on 27/2026.
My lord, okay. Can it be 28, Your Lordship? Because I have some fixed matter on 27, that's why.
No, it's okay. Let somebody be there. They'll not be hearing anybody that day. We'll file for delivery of order.
All right.
This is the matter on 27/2026 under the heading open inverted comma for delivery of order.
Obliged.
Obliged, Your Lordship.
Item number 14.
Please, Your Lordship. My Lord,
Just a minute.
yes.
Let me know. Item number? Yes.
My Lord, this particular appeal was admitted via order dated 22/5/2026, and paper book has been prepared and supplied to the respective parties. So the matter may be listed for hearing in its usual course, Your Lordship.
Okay. Mr. Alal Fakama, learned counsel for the appellant. And Mr.
Vanal Chanpuya for respondent number 1.
Vanal Chanpuya, learned counsel for respondent number 1. What about the others? 2 and 3? Government
Yes, Lordship.
are present and they submit that they have received a copy of the paper book. So they further submit that the matter may be listed for hearing. List the matter for hearing as per its own turn.
Deeply obliged.
Item number 15.
Five, six, seven respondents. Who is appearing? Yes. Mr. Ramzawa, this is your case.
Yes.
Why is it listed today?
Notice has been furnished to the respondents, Your Lordship. Appearance will be made by
Lordship, if I may, I have filed my bakalat nama yesterday for respondent 6 and 7 on behalf of respondent 6 and 7. However, our names are not reflected in the cause list.
What about 5?
5 Fatima.
Are you a part? Are you representing 5 also?
No, Lordship, 6 and 7.
And what about the others?
Others 1 to 4. They all state. 5, we have taken steps for service by Talabana. 6 and 7, they have made their appearance. 6, 5 are here.
What about the TCR? Not yet received.
No. May be called for, Your Lordship.
It was already called for. Where is the correspondence file? AD card from the district judge. Please write Mr. Sila Ramzawa, Learned Senior Counsel, assisted by Mr. Stephen Lal Botsai, appears for the appellant, and submits that they have taken steps for service of notice upon their private respondents, is directed by this court. Stop at this stage. Ms. Ruth Lalwatfeli, Learned Counsel, submits that she has instructions to appear on behalf of respondent numbers
6 and 7.
6 and 7, and that she has filed her power yesterday. She also submits that her name may be reflected in the cause list. Stop. Insofar as respondent number 5 is concerned, let service report be awaited. Stop. Ms. Lal Nundui, Learned Government Advocate, appears for the respondent numbers 1 to 4. Next para. Although AD card has been received back from the District and Sessions Judge ISO, but TCR has not been sent. Stop. Accordingly, registry shall send a reminder. List the matter again on receipt of the TCR.
No, please.
From admission list, item number 3 to 7.
Hey, one more line. The registry to reflect the name of Ms. Ruth Lalwatfeli, Learned Counsel, as the counsel for respondent numbers 6 and 7.
So, Lordship, my senior's name also, Mr. Elias Janshima.
Okay, 2 names, huh? Registry to reflect the name of Mr. Elias Lanshima, Senior Counsel, and Ms. Ruth Lalwatfeli.
Obliged.
What is this item? 3 to 7, okay. Yes, Mr. Ramzao.
Lordship, this is a matter regarding
Your Lordship,
the contract.
if I may, Your Lordship, I'm appearing for in item number 6. Sorry, Your Lordship, if I'm preparing for the state in item number 5 among the analogous cases. Your Lordship, if I may be allowed to file an additional affidavit in this regard, because there is a certain additional information that I would like to add into the affidavit. It pertains to a submission which has been made by the petitioner themselves in their affidavit, in their writ petition regarding the alternate dispute review that is available for if there's any dispute which is arising out of this agreement, Your Lordship. So if I may be allowed to file an additional affidavit pertaining to that particular provision of the agreement of the contract, Your Lordship. And it will not be adversarial prejudice the writ petition's interest.
So that will be only in item 5. What about the others? They're all clubbed together.
Case is similar, Your Lordship.
It is similar, Your Lordship. So if required, Your Lordship, if I may be allowed to at least seek instructions as to whether the...
No, what precisely do you want to file in the affidavit?
Your Lordship, regarding the fact that in the agreement signed, that is also in the annexure 8, that starts from page 54. On page 61, Your Lordship, it talks about dispute. So the procedure for dispute resolution, it talks about dispute review expert. And also it talks about arbitration. So, Your Lordship, in our affidavits, we have not mentioned any of those. If I may be allowed to submit the same in a form of affidavit, Your Lordship.
So, in other words, you want to mention about the maintainability of the writ petition.
Yes, Your Lordship.
This, since there are some other remedies provided in the
Yes, Your
agreement.
Lordship.
That can be addressed during the course of hearing, Your Lordship. Because the facts are well highlighted. They have stated that the alteration in the contract amount, that is because of certain difficulties, and they have said that there is a provision in the contract agreement itself as per the version. So as a result, we have made this alteration. So whether that alteration would come under the provision of the agreement, that is one thing. And Even in the absence of such additional affidavit or whatever that she's trying to say, I think the matter can be adjudicated.
That is there, but unless the opposite party makes a point on that for you to counter it, there's no question of countering it. So it will be basically an oral,
In fact,
argument
they have made it. They have made it. They have made a point on that
in the affidavit.
in the affidavit itself.
Your Lordship, not in this particular affidavit which pertains to my case, not in the item number 5, Your Lordship. We have not made.
But they are all one and the same, I think.
Yes, they're all in the same. In fact, there's
And
a
who's appearing
provision.
for the other cases? Mr. Samuel,
I'm appearing for 4 and 5, my lord.
4 and 5.
Yes, my lord.
But 5, she just said that she wants to file additional
3 and
affidavit.
4. 3 and 4 is the learned AAG. 3 and 4.
Okay.
And then 6 is Mrs. Carolyn. And 7 is Mrs. Mary.
So all of you are here? Where is Mary?
Only Miss Mary is absent, ma'am.
In fact, this WPC 33 of 2024, if this matter is decided this way or that way, in whatever way it may be decided, it will cover the rest of the matter. Because what I have stated in our writ petition, there's a contract agreement for a particular work amounting to so and so, and in the meantime, while the work is in progress, there's a reduction of the amount that has been allotted to, that has been given to the petitioners.
Is there any clause in the agreement saying that the amount can be reduced at?
There's no such clause.
Okay.
There's a provision for a redressal of dispute. And the
Say,
kind of dispute,
according to you, if the contract is settled at supposing, say, 10 lakhs, you should be allowed to complete the entire thing.
yes.
Midway, they cannot reduce it to just work of 5 lakhs.
What we have challenged is the order, the finance department's order for reduction of the amount.
That you have challenged also?
Yes.
Okay. What was the reasoning given? Austerity.
Not austerity, because of the fact that this SASKI, under SASKI, first installment has been given on the basis of the projects which have been submitted by the state government. A number of works have been approved by the central government, and based on that, sanction was made. And based on the sanction, the tenders were issued. And after the issuance of tenders, the contractors were selected, and thereafter agreements were made. And thereafter, when the contractors were about to proceed, they were given direction not to proceed with the work. And it was during the transition period. Transition means at the end of the 2023, there was a change in the government. And the new government that has taken over was not in a mood to allow the contractors to continue. And in spite of all that, they have made the agreement with the contractors. After signing with the petitioners the agreement, they are supposed to proceed with the work. And when the work was to be proceeded, they were verbally informed that they are not supposed to proceed with the work at that stage. And the engineers concerned, they did not want to go to the spot and inform the petitioners as to what to do. And in spite of all that, the works were started. And after the works were started, there was the order, which is at page 84, Your Lordship, it's Annex 9. This is an office memorandum dated 15 February 2024. 15 February 2024. This is on the subject of instruction for implementation of works under Part 1 of Special Assistance to State for Capital Investment 2023-24.
Page 89.
Page 84, Your Lordship. I'm reading from WPC 33 of 2024, Sri Rokima. Your Lordship,
See, before we delve into the matter, what do you say about the additional affidavit they want to file? Yes or no? That has to be looked into.
I have some objections. My Lord, this matter has been protracted due to one thing or the other, and now these are the works which were of 2023-24, and now we are in 26.
Your work value has been decreased.
It has been decreased.
Then the work value which has been allotted to you, have you completed that?
Yes, that no. The work which has been given to me at page 97, you'll see.
Have you completed your portion which, according to them, should
That
be?
we have completed.
You have completed.
Yes.
What about the balance of work?
The balance work is still there.
What kind of work is this?
It is regarding upgradation of internal roads at Hunthar, San Mari West, Rangvamual, Punsong, and Singaveng.
So
The initial work value is rupees 300 lakhs.
no, that's okay. See, what I'm trying to ask you is, supposing you have to construct a road. They say, no, you don't construct the entire road, you construct half the road only. What will happen to the half of the road?
It is upgradation. It's upgradation under a scheme.
Maybe upgradation. So only half of the road will, half of the stretch of the road will upgraded. The remaining will remain as it is. Or what? What is the situation?
Some work have been allowed to be executed so far as it is covered by 21.32%. Only 21.32% of the tendered amount has been allowed to be executed by the petitioner.
So that percentage, have you completed that percentage?
Yes, that so far as that's concerned.
You have completed. What about the payment for those?
Payment was also made.
Made.
Yes.
So the remaining of how much? 79.
Yes.
79% of the work. What will happen to that?
That still needs to be done.
No, they have prohibited you from going beyond.
That's why you have approached this honorable court.
I understand. Supposing, I mean, there has to be reason behind why they have.
The reason is, Your Lordship, this is the first office memorandum in that regard. Here at page 84, at Annex 9, what they have stated. May I read, Lordship?
No, just a minute. Let us be clear about their objection and your objection. What is the difficulty on your part? Just that affidavit to incorporate that there is some other
Alternate remedy.
remedy.
Yes, Your Lordship. That should have been
that is
complied
on
with.
that is on the basis of the agreement, isn't it?
Yes,
Agreement
Your
also contains that clause.
Yes, Your Lordship.
You can always point that out in the argument. What is there to file an affidavit?
But then, Your Lordship, that also, if the agreement itself contains an alternate remedy, that should have been exhausted. That is the argument that we would like to submit.
No, that's what you can raise that argument orally, verbally.
But then, Your Lordship,
For that reason, you don't have to file an additional affidavit just to incorporate that.
At the same time, Your Lordship, the arbitration clause will have certain, it's a special provision, so it will entail a different,
No, I don't think you get the point. Don't take time just for the sake of taking time. If you're not ready, say so. We'll permit you to argue on that. Maintainability, this, that, arbitration, what not are there. You raise, he also gave his reply to that. But as rightly pointed out by Mr. Ramzao, I think you don't have to file an additional affidavit for that.
yes,
He's
sir.
also not objecting to your submission. He will not object to you raising this point. He will reply you, that's all.
Yes, Your Lordship.
Now, unless the parties concerned are enthusiastic of dealing with this matter, this court also is not inclined to, like just press people to do cases like that. But this is not your basic case. It's the case of your clients, respective clients. So the interest is the concern of the court. And since they are all analogous, the
Yes.
issues are analogous, they've been clubbed together. In some cases, you have already raised this issue in your affidavit. In one or two, you may have not raised it. So you need not have to worry about that.
Yes, Your Lordship.
If you want time to prepare, we'll give you that. But otherwise, on this ground, I don't think we should adjourn it.
No, Your Lordship, if that is the case, Your Lordship, then the matter can be heard today at full length.
Yes, your colleagues, Mr. Samuel, you are agreeable?
We can proceed, Mullah.
All right, good. Now, if there's some practical hurdle, some issue which has to be addressed by filing of additional affidavit, I understand. If it's not there, let us not adjourn the matter like that. Yes, Mr. Ramzao, you may start.
Lordship,
We are at item
this-
number 3, isn't it?
item number.
We are at item number 3.
Yes, yes, Lord. Lordship, the basis of the work, that is the sanction under SASKI. Your Lordship, if I take Your Lordship to Annexure 1, this is guidelines on the scheme for special assistance to states for capital investment. That is at Annexure 1,
Page?
page 20. Your Lordship, under this guideline, under this scheme, there is a financial assistance.
And it's, both of you may go. I'll call you out. Guidelines.
Guidelines on the scheme for special assistance to states for capital investment. Lordship, this scheme, under these schemes, the financial assistance has been provided to the state governments in the form of 50 years interest-free loan. 50 years interest-free loan. That has been indicated under para 1, the last two lines. Financial assistance to the states, to the state government in the form of 50 years interest-free loan. So that, I mean, under that scheme, this particular scheme is of 2023-24, and the loan amount is to be spent within the financial year 2023-24. Last line of the said page, page 20. And we are governed by page 21, para 3, 1, subclause 1, part 1. Scheme for special assistance states for capital investment 2023 has the following parts. 1, part 1, untithed. An amount of rupees 1 lakh crore is earmarked for part 1 of the scheme. This amount has been allocated among states in proportion to their share of central taxes and duties as per the word of the 15th Finance Commission, state-wise allocation of funds under this part is given in Annexure 1. If I take Lordship to Annexure 1, at page 29. Under serial number 17, there is Mizoram and interstate share of state in central taxes and duties in percent. That is 0.5, and the total allocation under part 1 is 500 crore. That is for Mizoram under this particular scheme of 2023-24. Your Lordship may peruse para 6 at page 26. Para 6, Your Lordship. Funds provided to the states under the scheme by the Government of India may be used by the state governments for new and ongoing capital projects for long-term benefits to the state. The funds may also be used for settling pending bills in ongoing capital projects. May I take a Lordship to para 12? Funds not used by a state within a reasonable time may be reallocated to other states by the Government of India. In case of unavoidable changes in specific projects for which expenditure is sanctioned, state government shall seek the approval of the Government of India for the change. So here, if there is any change to be made due to unavoidable changes in specific projects, the permission or approval of the state government, the Government of India needs to be obtained. Funds will not be released against unapproved changes and may be deducted from subsequent installments or tax devolution if already released. Lordship, para 15. The amount released by the Government of India shall be released by the state government to the implementing agencies or SNA of the state within 10 working days. Delay beyond this period will make the state liable to pay interest to the Government of India on the amount released as per the weighted rate of interest on open market borrowing. That is 10 years section for the previous year. And para 17. The consolidated utilization certificate for the amount utilized up to 31st March 2023 in the form so and so against the amount released in 2022-23 under the scheme for 22-23 duly signed by the Finance Secretary of the State Government will be provided by the State Government, failing which equivalent amount will be deducted from the first installment of funds released to the state under the scheme for special assistance to State for Capital Investment 2023-24. The guidelines will come into effect from 1st April 2023 as provided under para 21. So, Lordship, this is a special scheme and it is very useful for the purpose of making infrastructure development of the state. Road works and buildings and number of works have been executed under this.
This is an interest-free loan.
Interest-free loan for 50 years. 50 years, interest-free loan. And may I take a Lordship to page 33, it is Annexure 2.
If it's a loan, it has to be repaid back
It has to be paid back
by the state.
by the state but without interest,
without interest.
and within 50 years. And every state, every government, they spend whatever amount they receive, and for the progress and for development of the state. And as a matter of fact, they're not thinking in terms of repayment, because it is within 50 years that repayment period has been scheduled. So anyway, that is one part of the matter. And here, at page 33, Your Lordship will see the letter dated 28 July 2023 from the Undersecretary Finance Department, Government of Mizoram, addressed to the Director, Public Finance States Division, Department of Expenditure, Minister of Finance, Government of India, on the subject of approval of projects under Part 1 of the scheme for special assistance to states for capital investment 2023-24, Phase 2. There's a reference. With reference to the subject and letter number cited above, I am directed to submit herewith list of project proposals in respect of Mizoram with a total estimated cost of rupees 300.76 crore for consideration and sanction as Phase 2 and a part of the scheme for special assistance to states for capital investment during the financial year 2023-24 as per format Annexure 2. Lordship, Annexure 2 is enclosed starting from page 34.
I cannot read page 34, okay? It's very minute.
It is very, very difficult to read.
Don't make me suffer.
These are the works. Anyway, Lordship. And in response to that, Your Lordship, the letter dated 21st August 2023 was sent to the Principal Secretary, Finance Department, State Government of Mizoram, releasing some amount of money to the state government. Here, Your Lordship, I am directed to refer to the State Government of Mizoram, letter number so-and-so, dated 28/7/2023. 28/7 is at page 33. 28/7/2023, submitting proposal of 52 projects in Phase 2, seeking special assistance of rupees 300.76 crore. Letter number so-and-so, providing clarifications, undertaking regarding branding guidelines, revised utilization certificate, and all that. In this context, it is to inform that the competent authority has approved the request of the State Government of Mizoram for approval of capital expenditure on the capital projects posed under the scheme for so-and-so for an amount of rupees 294.55 crore. That is rupees 100.76 crore under initial allocation plus rupees 193.79 crore under additional allocation as per Annexure 1 and Annexure 2 respectively. Lordship, these are financial matters and little technical, but the thing is that the amount that has been sanctioned to the state government has been released as per the Annexure 4 at page 47.
Estimated amount was 300.76.
Yes.
Now, what has been approved is 294.55.
294.455, Your Lordship?
Yes, that is the approved amount.
Yes, this is the approved amount.
Proposal estimate was 300.76.
Yes. And by this letter, which is at Annexure 4, this is a letter dated 6/9/2023 on the subject on account of payment of loan under Part 1 of the scheme for special assistance to state for capital investment. And this particular letter is addressed to the state of Mizoram. In respect of the state of Mizoram.
Which one?
This letter,
Page?
page 47.
No, it is addressed to the Ministry of
Yes,
Finance.
yes, Your Lordship. It is addressed to the Ministry of Finance. It is pertaining to the sanction to be released to the state of Mizoram.
Figures are different again.
Your Lordship, figures are different.
4,625, what is this?
For rupees
46254.
462 crore 54 lakh 97,931 li, being the first installment of loan under Part 1 of the scheme for special assistance to state for capital investment under Department expenditure, the state government of Mizoram for financial year so and so. And the amount that has been released by the Ministry of Finance is 4,625.9793 lakhs. And para 2, payments may kindly be made to the state government immediately. And there are certain conditions subject to the following conditions. Lordship, such release of fund was conditioned by these terms, 1, 2, 3. If I take a Lordship to condition number 2, amount released by the union government shall be released to the implementing agencies of the state government within 10 working days. Within 10 working days. The amount released shall be utilized by 31/3/2024. And the state government shall ensure that there is no duplication in funding of the capital projects approved under the scheme, either with the funds provided by the government of India or the state government. And point 5, in case of unavoidable changes in the specific project for which funds are being released, the state government shall seek the approval of the government of India for the change. Funds will not be provided in case of unapproved
This is
changes.
only a replication of what was read earlier.
Yes,
Correct.
Lordship. Then
In the guidelines itself, it has been provided.
thereafter, based on the sanction that has been made,
Then
the administrative
restricted tender has
approval-
been invited.
Yes, tender have been invited in respect of a number of works, including the work for upgradation of internal roads at serial number 7, Your Lordship. Upgradation of internal roads at Hunthar, Chandmari West, Rangvamwal, Punsong.
We are
Singapore.
concerned with serial number 7.
Yes, Your Lordship. And
See, the other matters also are here in this.
they're all here, yes,
Okay. Each separate individual work, isn't it?
yes, Your Lordship.
Insofar as this writ petition is concerned, we are concerned with serial number 7.
Serial number 7. And thereafter, the approved list of approved contractors selected for submission of restricted tender. There are four contractors. At page 51, serial number 13, the Lordship will see the list of approved contractors selected for submission of restricted tender for the work, upgradation of so and so. The name of Mr. R. Rokima, Chandmari West, at serial number 1. 2 other names are also there. And by a letter of acceptance at page 52, the Lordship will see
What does this mean? List of approved, selected for,
list of approved contractors selected for submission of restricted tenders. Lordship, this restricted tender is restricted to those shortlisted contractors. Among those shortlisted contractors, the selection was made.
what is the criteria for shortlisting?
There is a provision under the CPWD manual. Lordship,
Which says, what does it
because
say?
of, due to urgency in the nature of the work, and since this particular fund, which is sanctioned under SSP, is to be utilized within such and such period.
No, that's
The
correct.
work is to be completed.
That is correct. You see, restricted tender means not open to everyone. But on what basis they have three three firms or three contractors being chosen? What is the criteria?
Criteria, it's the department that makes a suggestion. Department makes a suggestion on the basis of the works performed by such class 1 contractors.
This is permissible.
Yes, Your Lordship, there's no dispute on that in this particular work. And tenders have been submitted by those shortlisted
Okay.
contractors.
Then
Then at
50
page 52,
52A is the acceptance.
yes, letter of acceptance in respect of the said work. The contract price is 8 crore 64 lakh and 4,000. 8 crore, no, rupees 8, no,
Cannot be
2 crore 88, yes. 2 crore
2.88
88, yes. And the performance security of 3% is 8 lakh 64,000.
Okay, so
That needs to be deposited within 14 days.
this has been done.
This has been done.
Notice to
And-
proceed the work, then agreement.
Yes.
Come to the agreement at page
There's
55.
issue of notice to proceed with work, and there's agreement. The agreement is in terms of the tender, the letter of acceptance.
Between the petitioner and the superintending
Yes,
engineer
Yes.
on behalf of the department.
There's letter of acceptance, notice to proceed with the work, contractors bid, contract data, and all those things are part of the agreement. Conditions of contract, general and special, specifications, bill of quantities, drawings, and any other document listed in the contract data as forming part of the contract. So it was duly signed between the contractor and the employer. The employer is represented by the superintending engineer, PWD. And Lordship, thereafter, if I take Lordship back to the agreement, it is dated 5 December 2023.
Yes.
And by the same date, on 5 December 2023, the petitioner was instructed to proceed with the work. And before that, the letter of acceptance was on 4th October 2023. There's a gap of 2 months. There's a gap of 2 months. Anyway, agreement was signed. And after signing of the agreement, the petitioner was to proceed with the work. And
What is this page 53, annexure 7?
Annexure 7,
Some deposited amount
yes, this
with
is
security,
security deposit, yes.
which amounts to how many, what is the percentage?
3%, Your Lordship.
3% of the value of the work.
Yes. 8 lakh 64,000. This is 3%. As indicated at page 52A, you are hereby requested to furnish performance security, which is 3% of the contract price. So 3% has come to 8 lakh 64,000. That was deposited. And thereafter, while the petitioner was to start with the work, there was a change in the government that had created all the problem.
Yes.
And if I take a Lordship to the following pages, at page 84, which I have shown earlier, at annexure 9. Annexure 9 is regarding instruction for implementation of works under Part 1 of SASKI 23-24. May I read the Lordship?
Yes.
It is hereby brought to the notice of all SASKI implementing department under Part 1 of SASKI 23-24 that an amount of rupees 5 crore has been approved by Government of India as new projects under Part 1 of the scheme, and consequently released an amount of rupees 266.69 crore as first installment, which is approximately 53% of the approved amount. Further, subsequent release of the fund from Government of India depends upon the progress of the implementation of the work and subject to submission of utilization certificate. However, it is learned that implementation have been inhibited due to the fact that first installment amount has been received just prior to enforcement of Model Code of Conduct of the general election to the Mizoram Legislative Assembly 23, and no capital works could be taken during the enforcement of MCC. As such, subsequent receipts of next installment is not certain, considering the progress of the works and the time left at this juncture of the financial year. All such scheme implementing departments are therefore advised to re-examine the approved project under Part 1 and to identify, prioritize, and select the works from the list of the approved projects that may be implemented completely within the received or reduced amount. That is approximately 51.88 of the total project cost for each implementing department, while the amount approved for SMS of JJM, that is 15.13 crore, may remain as it is, since it was already drawn and disbursed, and start the process of implementation at the earliest. Such selected list of projects and amount should be submitted to the undersigned at the earliest. So there is a directive from the Government of Mizoram Finance Department saying that because of the fact that there's a possibility that the second installment may not be available, because under the SASKI scheme, it is very strict and one has to go according to the scheme. If you don't utilize that particular sanctioned amount within the period allocated, then the second installment is not certain. So depending upon the submission of the utilization certificate, second installment will be released. So as a result of this office memorandum, and subsequent to this, the instructions have been given from the authorities of the PWD.
Let us read the second last paragraph again. What does it mean?
All SASKI implementing departments are therefore advised to re-examine the approved projects under Part 1 and to identify, prioritize, and select the works from the list of the approved projects that may be implemented completely within the received or reduced amount.
What is this within the received reduced amount? What is that?
The amount that has been received is 266.69 crore.
Okay.
That is as first installment.
First
While
installment.
the total sanctioned amount is
That is received.
500. Yes.
Then what is reduced?
That received has been only the first installment, and the reduced amount.
There is no question of reduction.
Here
they have received the first installment. That's
what
all.
might be meant is that it was earlier stated that it is 53%. Now here approximately 51.88% of the total project cost, because for state matching share of JJM, that is 15.13 crore, is included here in this 53%. So if this 15.13 crore is taken out, it has become 51.88%. So that's why I think it is stated as reduced amount.
No, see, the amount that was released is 53% approximately
Yes.
of the
yes.
approved amount. How has it become 51.88% now?
Now, after deduction, this 266.69 crore includes 15.13. 15.13, which is the amount approved for SMS of JJM.
What is this?
JJM is Jal Jeevan Mission.
An SMS?
This SMS is state matching share. It used to be SMS. I think this also SMS is a state matching share. So 53% has become 51%, 51.88%.
How has it become 51? That I'm not understanding.
Out of 500, 266.69%, no, 266.69 is 53%.
Correct. That is released.
Yes. If 15.13 is deducted from 266.69, then
It becomes 51.88.
it becomes 51.88.
Now this 15.13 crores, why it has been deducted?
It has been deducted because it has been earmarked for JJM, Jal Jeevan Mission. That is for supply of drinking water. It comes under a different scheme. This has been included in this SASKI. 15.13 crore may remain as it is, since it was already drawn and disbursed, and start the process of implementation at the earliest. So far, there's no disputes as to the amount. This is the first installment. As to whether second installment will come, depends upon the performance of the state. And pursuant to this office memorandum, the chief engineer, PWD, had instructed all superintending engineers, PWD and the chief engineer roles, Lordship, as can be seen at page 86, Annexure 10. And here, Lordship, it states, with reference to the subject cited above, I have the honor to send herewith the above mentioned office memorandum for your kind information and necessary action. It may be mentioned here that the administrative approval, along with the name of works, should not be changed and the sanction amount should be curtailed within 53% of the sanction amount. That is, first installment already released, without changing bills of quantities and agreement, so that the bill should be prepared incomplete final within 53 of the sanction amount as per finance memorandum. Lordship, this instruction itself is in violation of the agreement.
That is one thing. See, what was the deadline otherwise? Fund has been sanctioned under SASKI,
Yes.
then restricted tender invited, the prospective contractors selected,
Yes.
agreement signed, but the work was not executed.
Work was not executed for quite some time, and in the meantime,
And not
directives-
executed. In the meantime, this office memorandum came, which says that you have to restrict the work to the
Yes.
first installments which has been received, and identify and prioritize the select works. So this came from the finance department. Then the PWD again had written to all the officers concerned
Yes.
to comply with the same. That means to curtail the work up to the amount sanctioned, that is 53%.
The date of completion of the work as per this issue of notice to proceed with work at page 54 is that please note that the time allowed for completion of the work is 12 months and commencement date of the work shall be counted from 10 days from the date of issue of this letter.
12 months.
12 months.
No, this is an instruction, internal arrangement by the government of Mizoram
Yes. So
in the department of.
what is meant by this letter is that within the sanctioned amount of 53%, they have to stop the work. They have to allow the contractors only up to the extent of the sanctioned amount,
Okay.
irrespective of whether there is a possibility of having the second installment under the same scheme. So since they were of the opinion that since the work was started late and because of the MCC, the work could not be started immediately after the selection.
Otherwise,
Letter of
work,
acceptance was in October and the agreement was in December 10. So two golden months were wasted. And when agreement was made, the petitioners, the contractors, were about to start their work, and the
they
said
were
instruction-
verbally informed
yes,
not to do the work.
Yes,
That was your case, I think.
yes, they were informed not to
Now,
proceed with the work, and it was hotly debated even in the Legislative Assembly, and during that discussion, questions were asked from the opposition parties, as reflected here in Annexure 11, Your Lordship. At page 89, the English translation is at page 89. There's a letter addressed to the engineer-in-chief, wherein the selected contractors had submitted their representation. Your Lordship, the answer, may I read, Your Lordship, the letter?
Which portion do you want to read?
From the beginning, it is a short one.
It's not required.
Let me read from
Let
the
us
middle.
Read the relevant
Answer
one.
given by PWD Minister on Assembly start question asked by Robert Romo as
Read
what
the last
mentioned
paragraph. Read the last paragraph.
during session, Your Lordship.
Yes.
During the session of 9th Mizoram Legislative Assembly on 29/2/2024, Honorable Chief Minister, who is holding Finance Department, in his clarification to the ongoing SESCI work said, contractors under SESCI are allowed to continue their works. Not even one contractor is prohibited to proceed. We want them to work fast. I want all contractors to know this. There is no contractor to which we put pressure on to sign bill of quantity. Since the Chief Minister himself had made an announcement inside the August House before the people of Mizoram regarding the ongoing SESCI contract works, we have no other option than to conclude that all the reasons behind our problem regarding late commencement of works, BOQ reconstruction, slow progress of works, etc., were created artificially by and within the department level. Therefore, as we had already stated in our previous letter, we have no other option than to prepare ourselves to approach the law court. In order to implement the announcement made by the Honorable Chief Minister at the August House and to do away with the allegation leveled against us that we are implementing the works very slow, and due to the reason that the already signed formal contract agreements are time-bound, the work proposals you have made for the development of the people and the state now need to be implemented in a speedy manner. We had already wasted the precious working season of almost 3 months due to the said verbal instruction, verbal stay order to complete the works on time. Now every day counts. In view of above mentioned reasons and considering the contract agreements and to avoid seeking court's intervention and not to waste any more time, we sincerely request you to give instructions to division under your commands to conduct site inspection with the concerned contractors and to take necessary steps to expedite the works.
So this is your representation.
This is the representation which was submitted.
This is your representation.
Yes.
Then
Thereafter, the works were started. And in fact, even at this time, the ongoing works were there. This letter was of
The presentation is of 7 March 24.
7 March, yes, 7 March 2024. And here in the impugn order, Your Lordship, there's so much of reduction of the amount.
Where's the impugn order?
The impugn order is at page 91. In fact, even the first impugn order is of the letter of his memorandum dated 15 February 2024, and this order dated 27/3/2024 is also another impugn order. And here, Your Lordship will see from the order, there's a proposal for determination of the amount. Governor of Mizoram is pleased to accord expenditure sanction of rupees 214 crore 4,56,000 only against the previous amount of 21 crore 700 lakh. No, 21 700. Yes, for 104 numbers. Under Special Central Assistance to State Investment, Part 1 doing so and so, and under 1 and 2, on condition that if the sanction amount has been already drawn, difference of original sanction amount and revised sanction amount, that is rupees 295.14 lakh, should be deposited into government account. So here, a number of works has been listed. The work which is particularly we're concerned with is at page 97. Page 97, serial number 10. Under B, no, under C of Part 2. There are two parts. One is all those works mentioned prior to page 96. From page 96, the second part, part 2, starts. And under part 2, A, B, C. Under C, the serial number 10 is regarding upgradation of internal roads at Hunter, Chanmari West, Rangwamual, Punchong, and Singaveng. Here, Your Lordship will see the first column. The first column under AA accorded. AA accorded in respect of the said work is 300 lakh. And 300 lakh is the AA accorded, but the tendered amount is 288 lakh. There's no dispute about that. And out of 300 lakh, the ES concurred under ID number 902 dated 6/10/23. It is 160 lakh. And again, revised expenditure sanction under the third column is 61.41, which comes to 21.32% of the tender amount.
See, you're not aggrieved if the thing continues as 160.
No. I'm
Expenditure sanction,
I'm aggrieved even with that.
administrative approval is 300.
Yes, but I'm not vying for 300.
Correct. See, the tendered amount is
Yes,
2 crores 88 lakhs,
Yes.
2.88 crores. Administrative approval is 300 lakhs or 3
Yes.
crores. Now, the expenditure sanction has been given as 160,
Yes.
160 lakhs. Then which has further been revised
Yes.
to 61.41.
Yes.
This is in terms of the the instruction issued?
That is because of the anticipation that the second installment will not come.
Office memorandum of 15 February,
Yes,
because of that.
Annexure 9. Lordship, in this connection, the humble submission of the petitioners is that they have been given the work for which they have made the agreement with all the bills of quantities accepted by both the parties. And there's a terms and condition which has been duly made during the course of the agreement. And when the amount is reduced, according to them, in fact, there is no reduction.
See, do you have any information regarding the second installment?
Yes, Lordship, my humble information is that because of the late implementation and non-submission of UC, the second installment could not be sanctioned or released.
It could not be released
It could not be released.
till now.
Yes, that's true. Lordship, the
So their apprehension is correct then,
apprehension,
if it is not
it
released.
was, the problem was artificial. It was made by them. It was made by them because of non-implementation.
Apprehending that the second installment may not be forthcoming because of some delay, they wanted some reduction in the sense that it should be restricted to the installment received. Now you say that the second installment has not come.
It has not come. So, under the given circumstance, what we have stated is that it is now the responsibility of the state to provide the said amount, the said fund from the state exchequer. If it cannot be availed from the SASKI, from the government of India, then it has to be made available by the state. Why that should be done, we have properly explained in affidavit in reply. Lordship, if I take Lordship to the affidavit in reply, the stand of the respondents first is that, Lordship,
Stand will be in the affidavit of opposition.
yes,
Reply is yours.
yes. All these works,
What is the stand?
all these works were reduced to the said amount and as directed in the letter dated 15/3/2024, the works were prioritized. Works were prioritized, and then all the works shown in the BOQ and the agreement could not be undertaken. As a result, the works were prioritized as per the importance given by the state. That is, in sum and substance, the stand of the state government. And as a result, it is necessary for the state to reduce the work and the amount, in view of the amount that has been sanctioned. In fact, Your Lordship, the scheme does not say that only first installment should be provided to the states. The total sanctioned amount, administrative approval which has been given is 500 crore for that particular work. And out of that, if the works are performed as per the scheme, then the second installment will have to be released. But the second installment could not be released because the utilization certificate was not submitted by the state within time. What is very glaring is, if I take a lordship again to page 27 of my writ petition. Yes. They have clearly stated that the amount released by the government of India shall be released by the state government to the implementing agencies of the state within 10 working days. Within 10 working days. But as indicated here in the...
So when do we start counting that 10 days? From which
10
date?
days is from the date of release. That is,
Which is that? Which is?
this is 6/9/2023
Where do you get that? 692.
at page 47. Page 47, Annexure 4. Payments may kindly be made to the state government immediately.
Page 40,
Page 47.
47. Date, you've given the date is 6/9.
6/9 is the date of the letter. And the condition that has been stated here is the term and condition number 2, the amount released by the union government shall be released to the implementing agency of the state government within 10 working days. And the amount released shall be utilized by 31/3/2024. While this is the condition for sanction of the second installment, Your Lordship, if I take Lordship to my affidavit in reply, at page 5, para 11. What I have stated here is that with regard to the statement made
There
in
are-
para 14,
How many affidavits have you filed?
only one affidavit.
There are 2 affidavits filed by the respondents. 1 to 5 and one is respondent number 6 separately.
Respondent number 6 is the funding agency, that is
Who is that?
the Ministry of Finance.
I see.
They are just washing their hands.
And your reply is regarding, is against the affidavit of the
Affidavit in
respondents 1 to
opposition
5.
of the respondents, 1 to 5,
Okay.
yes. With regard to the statement made in para 14 of the affidavit in opposition, I beg to state that the petitioner is supposed to start work only after signing of the contract agreement on 5/12/2023, thereby resulting in loss of the best working period of the first 2 months after issue of letter of acceptance on 4/10/2023. However, in spite of the said delay in execution of the works by the petitioner was in a position to completely and satisfactorily execute the work if the respondent had not caused disruption in execution of the work by the petitioner. In this connection, it is humbly submitted that utilization certificate in respect of the amount sanctioned as the first installment could have been submitted by the respondent number 1 to 5 had the Finance Department transferred the fund released by the Government of India, respondent number 6, void letter dated 6/9/2023, within a period of 10 working days, as stipulated by the said letter, to the SNA, single nodal agency, that is state PWD. The fact that Finance Department, that is respondent number 2, had failed to discharge its lawful obligation in transferring the said fund to the SNA can clearly be seen from the RTI information given by Srimati Vanalfo SPIO Superintending Engineer, Engineer-in-Chief, to Sri H. Lal Himpuya of College Veng Aizol, in which it was clearly stated that the first installment of Saski Fund amounting to rupees so-and-so was transferred to PWD accounts on 11/6/2024. So, well, it is expected that they should transfer the said fund to the SNA, that is PWD, within 10 working days. It was transferred only on 11/6/2024. That is 9, 10,
No, the same
9
day.
months. Yes. 9 months.
Transferred to the PW 11/6.
Yes.
9 months means counting from?
Counting from the date of 9/6/2023. That is the date of sanction, and the date it was released to the state government. And in fact, what is meant by utilization is a transfer of fund from finance department to the PWD. This is the utilization. And on transfer only, on transfer of the fund from finance department to the SNA, only the utilization certificate could be issued. That means when they transfer the fund from the state government to the department concerned for the purpose of utilization, then the utilization certificate will have to be submitted. As a result, utilization certificate could not have been issued by the respondents number 1 and 2 till the said fund was transferred to the implementing agency on 11/6/2024. Thus, it was the respondents number 1 and 2 who had intentionally caused delay in implementation and execution of the work, and not the petitioner. It is the respondents number 1 and 2 who are responsible for the delay. Mention may also be made of the response made to the 3 questions asked by Naldu Thana. The question and answer in connection with the said online RTI application submitted on 22/5/2024 had confirmed that non-releasing of the second installment amounting to rupees 233.31 crore to the state government by the respondent number 6 was due to the faults of the state respondents. Consequently, the state must bear the costs for execution of the remaining work from its own resources if the respondent number 6 cannot release the second installment. So the fact is now very clear that this respondent number 6 cannot release the said second installment because of lapses on the part of the state government. They are keeping the said amount for so long, for 9 months, while they are to retain only at the most for 10 days. The respondent number 1 to 5 are therefore liable to be directed to comply with the agreement which they had signed with the petitioner for execution of the said work with a contract value of rupees 2.88 crore. Your Lordship, I have annexed here the online RTI application, which is translated at page 16. Your Lordship, this is very important for the determination of the issues involved here. The question is, under number 1, under Mizoram Saski Part 1, an allocation amounting to rupees 500 crores was given for the year 2023-24. Within how many days does the Mizoram Finance Department have to transfer the first installment amounting to rupees 266.69 crores to implementing department as per the central government finance ministry guideline? The answer given is, as per the central government order, Saski Part 1 so and so, first installment received for financial year should be transferred to the implementing agency within 10 working days from the date of release. The second question, the above mentioned first installment was said to be not released by your office during financial year 2023-24, even on the last day, that is 31/3/2024, by the Mizoram Finance Department. Can the Central Finance Ministry release the remaining second installment amounting to rupees 233.31 crores to Mizoram, while the first installment has been retained during the financial year 2023-24? The answer is, to receive the second installment amounting to rupees 233.31 crore, 75% of the first installment funds must be utilized. We could not achieve this since 2023-24 has been long gone. It is not expected that the central government will release the remaining 233.31 crore. Question number 3. Whether the funds of Saski Part 1 amounting to rupees 266.69 crores released for financial year was withheld by your office without releasing the said funds to implementing department even after the end of the said financial year? Answer is yes. They have retained without any rhyme or reason. So it is for the purpose of thwarting the works which has been allotted to the petitioners that the said fund was not released to the implementing agency. And as a result, not only the petitioners, and even the public at large, and even the government is bound to suffer. Now, had they released the said sanctioned amount within the said period of 10 days from receipt of the said sanctioned amount that was sanctioned as first installment, Lordship, there would have been no problem. Now, it's only because of the regime change that all those things happen. And now,
Mr. Ramza, sanction was made on which date?
sanction was made on
6/9/23.
6/9/23.
This was a date on which it was communicated.
Yes. And here, payments may kindly be made to the state government immediately. If it was not released on 6/9/23, it may be released on 7/9. It is electronic transfer.
This letter was addressed to the Pay and Accounts Officer,
Yes.
Department of Expenditure, Ministry of Finance, and a copy
But,
given to the state.
yes, copy. At page 48, copy 2, Finance Secretary, State Government of Mizoram. And
But
Accountant
by
General.
this time, the selection of the tender or prospective contractors was not even started.
At this time,
By
it was not
6/9/23.
started. But the thing is, it has to be transferred to the SNA, that is the PWD. Now, the only thing is that the basis for starting with all those process, that is issuance of the NIT, selection being made, that was in the month of December.
So
And
when
in the
when
month
was
of
it,
October itself.
when was it transferred ultimately?
It was transferred ultimately on 11.6. The said fund was transferred to the implementing agency on 11/6/2024.
From where you're saying that?
I have stated that in page 6. Page 6. This is based on the RTI information.
6 of your reply.
Yes, page 6 of my reply.
But where is it given in the reply? I mean,
Lordship,
in the RTI reply, where is it?
RTI.
No, it's page 19.
Page
19.
19. Yes, yes, Lordship. We reference your application the RTIs and so on 11/6/2024. And as a result of this, Lordship, the petitioner have been made to suffer for no fault of their own. The contract has been signed and allotted. The work has been allotted to the petitioners with all the required formalities. And now it is the bounden duty of the state to fulfill its obligation in allowing the petitioners to continue with the work and to complete the work which has been allotted to them. And in fact, the security deposit, that performance security, which is 8,64,000, is still lying with them. And this security deposit of 3% is for the total amount of rupees 288 lakhs, 2 crore 88 lakhs, not for the meager amount of 61.41 lakh. So in view of this, Lordship, because of the violations of their own terms by the respondents, they are required to be saddled with the responsibility of making up the loss which has been unduly suffered by the petitioners and which has been occasioned purely due to faults and negligence on the part of the respondents. And the fact that the second installment is not forthcoming is certain as on date, because even in the RTI reply which has been given, there is no expectation and no hope because it has been long gone. And this litigation has been started in the year 2024. Now, the work which has been permitted by the respondents to be executed by the petitioners were well satisfactorily completed, but the remaining works are still there, and the remaining amount needs to be paid to the petitioners on completion of their respective works. So, Lordship, this is one of the...
No, payment will come after you do the work, isn't it?
On satisfactory completion of the work, yes.
So far as the reduced amount of work which has been made, that you have completed. For
Yes,
that payment you have received.
Yes. So
But
far,
for the balance amount of work under which, by the agreement, through the agreement you have been given certain volume of work, that balance work remains to be completed.
yes, yes.
So
And with
only if you complete that, the payment will arise.
yes. Since the second installment is not forthcoming now, it has to be paid from the state's exchequer. So they have to be, directed to make such sanction from their own exchequer, since they have not been able to avail because of their own faults. So, Lordship, there are other works, and I'll just
Is there any document to show that you have completed that balance, that work?
Lordship.
Any document to show that you have completed the reduced amount of work?
Yes, yes.
Where is it? In the reply? Or
In spite of the completion of even that part, part of the work, sanction, the payment was not released for quite some time. And in fact, we had submitted application to them, they refused, since we refused to sign the supplementary agreement with them. And the reduced BOQ.
but you said you received the payment.
We received the payment on approaching of, on the direction of this honorable court only. We approached this honorable court for
Direction of this
releasing.
court. By which order? Can you point out the direction of this court?
In some of the cases, even without direction, it was released.
Then why was the direction required then?
In some, it was not released, and Lordship, I just documents and all of it.
Anyway, you find out, let me listen, let me hear the other side.
Yes.
In the meantime?
In the meantime.
Yes, Mr. Samuel.
May it please, my lords. My lords, before I argue on the merits of the case, my lord, I'd like to draw your lordship's attention to the maintainability of the present writ petition, my lord. If I may kindly draw your lordship's attention to page 54 of the writ petition, my lord. Annexure 8, my lord. My lord, this is a letter dated 15 December 2023. Addressed to the petitioner, the present writ petitioner, my lord. This is subject issue of notice to proceed with work, my lord. This is letter is dated 5th December 2023. Now, after this letter was issued, my lord, an agreement at Annexure 9, page 55, my lord, was signed between the parties, my lord. And now, while signing this agreement, there is a condition of contract attached to this agreement, my lord. The condition of contract starts from page 57, my lord. 57, my lord. The condition of contracts. This is the table of contents. Now, if I may kindly draw your lordship's attention to page 62, my lord. Point number 24, my lord, disputes. Towards the bottom, my lord, after the disputes, it's at 24.4 in my, the copy that has been furnished to me, it's point 24.4, my lord. If the contractor believes that a decision taken by the engineer was either outside the authority given to the engineer by the contractor or that the decision was wrongly taken, the decision shall be referred to the dispute review experts within 14 days of the notification of the engineer's decision, my lord. And at point 25, there's a procedure for dispute, my lord.
Now, what is this 24.4?
This is if the contractor believes that the decision taken by the engineer was either outside the authority given to the engineer by the contractor or that the decision was wrongly taken, my lord.
Not contractor, by the contract.
By the contract or that the decision was wrongly taken, the decision shall be referred to the dispute review expert within 14 days of the notification of the engineer's decision, my lord.
So where is the engineer's decision?
Well, my lord, the affidavit in opposition filed by the state, my lord. The authority that was given, my lord.
Was there any decision of the engineer?
Yes, my lord. If I may kindly take your lordship to page 15 of the affidavit in opposition, my lord.
Of 1 to
Of
5?
the affidavit in opposition of the state, 1 to 5. my
1 to
lord.
5.
Yes, my lord.
Page?
15, paragraph number 19, my lord. If I may read, my lord. That with regards to the statements made in paragraph 18 of the writ petition, I say that reduction of clause of work as per the direction issued by the government is not in violation of law. As in contract, if either parties have a problem, there is always a clause for termination, which was not the first choice of the respondent, as the work was already allotted to the petition, and instead the department requests him to sign a supplementary agreement, which he has now disputed, my lord. Now, in order to show the power as per the contract agreement clause 12, my lord, we have reproduced clause 12, my lord, which reads as follows, my lord.
Clause 12 of the agreement.
Yes, my lord. An extract of the clause 12 is given at page 74, my lord, in our affidavit in opposition.
In the main writ petition, where is it available? Is it available or not? Because agreement is there.
Yes, my lord. If I may read clause 12, my lord.
No, clause 12 of the agreement. Page 55 of the writ petition is the agreement.
Yes, my lord.
Where is clause 12? There's no clause 12. So from where have you abstracted this? Condition of contract is different.
Yes, my lord.
Agreement comprises of only 2 pages. Paragraph 1 to 4. So from where do you get this clause 12?
As per this agreement, my lord, there is this. There is a condition of contract, also a special condition of contract is also there, my lord.
Where is that?
It's at page 72 of the writ petition.
72. Special of,
Page 72 of the writ petition, my lord.
no, correct, 72, special condition of contract. What
Yes.
is this? This is in continuation of the agreement.
Yes, my lord.
Now, where do we get clause 12?
have given an extract copy, my lord. It's in the affidavit in opposition, page 74.
I want to know I want to know the origin. You are showing me the abstract.
Yes, my lord.
Show me from where you have abstracted it.
We have not annexed the full clauses of contract, my lord. We have just extracted clause.
No, no, no.
12,
It
my lord.
cannot be like that, you see.
This clause inserts the engineering charge power, my lord, where he can make alterations, my lord.
Correct. So it has to be somewhere in the agreement. Where is it? You have given me only the abstract.
I can get the full clauses of the contract, my lord.
See, come to page 55 of the writ petition.
Yes, my lord. This is the agreement signed.
Agreement is signed is only paragraph 1, 2, 3, 4. Paragraph 4 says that these also will also be a part of the agreement. Correct.
Yes, my lord.
Subclause 1, 2, 3, 4, we're not concerned. Then 5 is conditions of contract, general and special. 6 is specifications. 7 is BOQ.
Yes, my lord.
8 is drawings. So this clause 12 will contain in which part of these documents? Anyway, you read clause 12. What have you abstracted? Let's see.
If I may, my lord.
Yes.
The engineer in charge shall have power to make alteration in omissions from, additions to, or substitutions from the original specifications, drawings, designs, and instructions that may appear to him to be necessary or advisable during the progress of the work, and number 2, to omit a part of the works in case of non-availability of a portion of the site or for any other reasons, and the contractor shall be bound to carry out the works in accordance with any instruction given to him in writing signed by the engineer in charge, and such alterations, omissions, additions, or substitutions shall form part of the contract as if originally provided therein, and any altered, additional, or substituted work which the contractor may be directed to do in the manner specified above as part of the work shall be carried out by the contractor on the same condition in all respects, including price on which he agreed to do the main work, except as hereinafter provided.
It talks about the power of the engineer.
To alter the...
Correct.
Yes, my lord.
But who has altered the work? Page 91 of the writ petition. Is it the engineer?
The alteration was made by the engineer. However, this order dated 27 March 2024 has been issued by the Deputy Secretary, Public Works Department, my lord, at page 99.
In other words, the government who's done it.
Yes.
It's not the engineer who's done the alteration. So where does the power of an engineer come in the picture here?
As page 84, my lord, the office memorandum dated February 15, 2024. Annexure 10, my lord.
Correct. This is also not the engineer.
The implementing departments, my lord. At paragraph number 3, my lord. All such key implementing departments are therefore advised to re-examine the approved project under Part 1 and to identify, prioritize, and select the work from the list of approved projects that may be implemented, completed within the revised reduced amount, my lord.
Correct. So ultimately, it is not the engineer who has done the alteration or sort of, reduction of work and all that. We're talking about the powers of the engineer. Engineer has the power, and therefore, if the engineer does anything of that sort, the party can go for dispute redressal. Some mechanism is there. That is what you want to project.
Yes, my lord. In case of alteration, my lord.
Ah,
And
so
if the-
alteration has happened in because of the decision of the government in the finance department and the public works department, and engineer has abided by that. So challenging the engineer's decision will not do. Power has been exercised by somebody else.
Yes, my lord, but when the agreement was signed also, my lord, nevertheless, there is an alternative redressal.
Now let us see what is the alternative redressal. Page 62 of the writ petition.
Yes, my lord.
And where is this dispute review expert? Has it been constituted? Unless it is constituted, how do you refer it?
Only after him being aggrieved, my lord, the after the contractor being aggrieved, my lord, the matter was to be referred to the dispute reviewing expert, my lord. Within 14 days of the notification, my lord. Moreover, my lord, coming to the special conditions of contract also at page 72, my lord. At page 74. The alternative available to the writ petitioner is by way of an arbitration, my lord.
Page
74. Towards the top, my lord.
this is the procedure for arbitration.
Yes, my lord.
Before that, I think it is already given here.
At page 63,
63.
25.3, my lord. The arbitration shall be conducted in accordance with the arbitration procedures started in the special conditions of contract, my lord.
Where is the appointment for dispute review board or dispute review expert?
Constitution.
See, it is not your case that we already have a dispute review expert appointed. Petitioner, why has he come to the court? He could have very well given a complaint on that review for the expert. That you have not said anywhere. You just say that there's a clause for dispute redressal. That itself may not be sufficient. Annexure 7. You have not shown me this Annexure 7. The abstract is taken from Annexure 7, I think. Where is Annexure 7, by the way, in your counter affidavit?
Page 74, Mala. I'd shown it to you earlier, Mala. Clause 12.
Clauses of contract.
Yes, Mala.
This is derived from which part of the contract agreement? Clauses of contract.
If your lordship permits, we can produce this by way of an additional affidavit, the full clauses of contract, Mala.
No, you produce the record.
Yes, Mala.
Affidavit will be again some cumbersome process. You have to draft it, get it signed, get the instructions, all that.
No, just a copy of this contract, Mala.
That's why you produce the record. That
Yes.
will suffice. But you see, these are slightly different, I think. It's not regarding the reduction of the entire work like that. It is regarding some omission, addition, substitution from the original design specification and all that. That much power he has. But to scale down the entire workload from this amount to this amount, that was not the work of the engineer. It was the work of the decision taken by the government, the finance department. As we have just read out from this memorandum, apprehension was that the second installment is not forthcoming, so that's why they say that it should be scaled down. Engineers were asked to act accordingly, that's all. No. Yes, then one merits, what is your case?
At page 7, my lord, paragraph 13. This is the cause of the delay, my lord. Page,
Yes, read.
page 7, my lord. Paragraph 13. If I may read, my lord.
No, you just tell me,
Yes, my lord.
when was it implemented? When was it lifted? It is not there. You talk only about the lifting part.
It was lifted on 5th December 2023.
When was it imposed? That also you have to get instructions.
Yes, my lord.
Because
Only
you
the
can very-
lifting has been mentioned.
Because you might like to say us that this imposition was there. So we were just, like, debarred from doing anything at that moment of time, hence the delay.
Yes, my lord.
So that fact, that date, specific date has to be there. From this to this, now the lifting part is there,
Yes, my lord.
December.
5th December 2023. my lord.
Office memorandum came in February 24.
Yes, my lord.
But according to the learned senior counsel, the payment was made much prior to that. And 6/9/23 was the sanction. You were to act and made the payment within 10 days.
Yes, my lord.
So 9 means September. Whether the MCC was already in place in September or early part of October. Okay,
The specific dates I'll have to get instruction, my lord.
okay. This is regarding the thing, delay part. Then what else?
Page number 8, my lord. Paragraph number 2. Wherein we have stated, my lord, that the office memorandum mentioned is with an intention to facilitate the progress of the implementation of SASKI work so as to ensure that any halting of release would not result in committed liabilities. Also, that there is no actual reduction of the amount pertaining to work under SASKI by the state government, as the approval and release of fund is from the government of India, my lord.
What do you mean? Actual reduction is not there. Then how do you explain this 61.41?
Because this second installment, they were pretending that it would not be received because the work would not be completed in time, my lord.
So that is why, you see, in order to ensure that second installment is received, you had to swiftly act, release of fund within 10 days, get the work done. Because this is a benefit given to all the states
Yes,
who,
my lord.
who require such benefit. Zero interest, 50 years loan. Instead of being in that uncertainty mode, you could have acted swiftly.
We have also mentioned that paragraph, page number 9, my lord, towards the top.
What have you mentioned?
The top line, my lord, as there is little possibility of submission of utilization certificates in time to avail the second installment of SASKI 2023-24, and since the state cannot bear the cost for execution of the remaining work from its own resources in case the central government cannot release the second installment, it is therefore inevitable for the implementing department to curtail the contract, and for that the engineer and the contractor should either sign a supplementary agreement or the engineer prepares an incomplete final bill of the work, my lord. Coming to page, the same page, my lord, paragraph 16. This is in reply to paragraph 15 of the writ petition, my lord. On the third line, my lord. The government of Mizoram called a meeting of SASCI implementing departments on 5th January 2024 at Secretariat Conference Hall under the chairmanship of Home Minister Mizoram, who is also taking charge as Honorable CM at that time. The meeting is called mainly to discuss an idea of a roadmap for works that have not been started under SASCI Part 1, 2022, 2023 and 2024. Keeping in mind the main objectives of SASCI, which are creation of capital assets and settling of pending bills in ongoing capital projects. As per serial number 1 of the meeting minutes, Public Works Department was instructed to reprioritize all works that have not been started on ground for which expenditure sanction has been accorded by Finance Department, that is 53% of the total project cost, and Finance Department was to convey instruction to PWD. Accordingly, the petitioner quoted office memorandum was issued by the Finance Department that the PWD is to follow the office memorandum and has acted accordingly for implementation of SASCI 2023-2024. As the work order was issued and agreement was signed, there is no question of cancellation of work order. However, the work are curtailed and prioritized depending on fund
received much earlier to that. What is the date? What was the impediment in not starting to start the work? Meeting had to be held in January from the paragraph we just read, 5th of January 24.
agreement was signed on 5th December 2023, my lord, and the lifting of the Model Code of Conduct was on 5th December 2023, my lord.
Lifting,
Yes, my lord.
same date.
Yes, my lord. As per our statement at
So work could have started there and then. What was the difficulty? I think there was some uncertainty. So if I remember correctly, there was some verbal instruction not to start the work, according to the petitioner. They were verbally told not to start the work. Then this meeting happened in January 5th, which thereafter the office memorandum in February followed, correct? To reduce the scale of work, prioritize which of the work should be carried forward. So number one is the clause 12.
yes, my lord.
From where have you taken that you produce the records?
Yes, my lord.
Number two is the model of code of conduct. You produce the notification by which it was imposed and the notification by which it was lifted. And thirdly, whether the respondents are empowered to issue such kind of office memorandum to reduce the work. And if so, under what circumstances? What is the authority? What are the authorities? That you'll have to satisfy.
Yes, my lord.
Because all the other cases are in similar lines only.
Yes, my lord.
If one is decided in this way or that way, similar principle will have to be followed. And this particular annexure I could not read. Can anyone read this annexure? Page 30, 30,
Of the writ petition, my lord.
yes, of the writ petition, 34 onwards. Now, we are concerned with the upgradation of internal roads at Hunthar, Chanmari West, Rangwambol, Khunchong, and Chingaveng. Where do we get this particular item in this annexure?
At page 37, Your Lordship, serial number 17.
Sir Ramzao, you have a very good eyesight.
With the help of glass.
I can't just simply read it.
Should I read, Your Lordship? Upgradation of internal roads at Kunthar, San Mari West, Rangwamwal, Kunchong, and Singaveng.
Okay. So this was the project proposal
Yes.
in order to obtain the loan. Okay.
Lordship, may
So we'll keep it part heart. We'll hear it some other day. Let him get the instructions.
Alright.
I don't think there's a very
So
big issue is involved. There's the issues there only. Whether they can scale down the work, whether you can compel them to issue the remaining piece of work, and what would be the remedies available to you. And whether the alternative remedy, like you said, arbitration, the some dispute redressal board. You also obtain whether there's any dispute redressal board constituted. And if so, what is that?
Yes, my lord.
Because simply saying that there is a clause here, expert has to be, it has to be referred to the redressal expert or something like that.
Dispute review expert.
Ah.
There's a board, my lord.
Correct. So whether there's any constituted board, or only when there is a dispute, then only you'll constitute the board. What is the position?
Yes, my lord.
Might as well have the assistance of somebody who's from the department who's aware about this.
so far as, Your Lordship, the dispute as provided under this clause at page 62 is concerned, is a kind of disputes which are supposed to be quite minor. Minor in the sense that these are at the spot.
That's exactly what I indicated to the learned additional AG. Some minor drawing has to be corrected
Yes,
this way.
yes.
Instead of opening one door, he wants to open two doors now, and he wants 3 windows instead of 1 window. I mean, those kind of minor alterations here and there. There might be some dispute on that.
Which are to be decided at the spot.
That's it. But here,
but
we are
the-
concerned
the-
with the scaling
yes.
down
Yes.
of the work.
And so far as the question as to whether because of the possibility of having an alternative remedy, I have some citations, Your Lordship, which I may produce next
At the relevant time, yes.
11th time. Yes.
Existence of alternative remedy is not bar the court from issuing a writ. I think that is what you want to produce.
Yes.
And likewise, Mr. Simon also can find out some authorities.
I have, my lord.
You already have.
I'll produce
Okay,
it
that's
on
good.
The next court date.
Please, right?
So far as, Your Lordship, the order which has been made for directing the respondents. Yes.
Payment.
Yes. in case number IA Civil 124,
Arising out of
rising out of
WPC?
WPC 37 of 24,
Okay.
37 of 24, which we have not pressed. It has been disposed of
Oh,
as
not pressed. Okay. Okay. So how many cases were there in all?
6 cases were there. Now 5 cases are remaining.
Okay, one has not pressed.
Not
5
pressed.
are still there.
That is 37 of 24. In that, we had to file the IA for direction to the respondents to release payment
Okay.
in respect of a particular, I mean, so far
But
as the work has been
in respect of the remaining writ petitions, there was no specific
there
direction as
was no
such,
specific direction.
but they had
because-
released.
Yes, they were released because the release orders are there. So far as the present writ petition is concerned, 53,31,576 was released to the petitioner.
Okay, please write. Parties have been heard at some length. But however, the learned additional advocate general has to obtain certain instructions in the matter, which are as follows: colon dash number 1. The notification by which the model code of conduct was imposed in the year 2023, correct?
Yes.
And likewise, the notification by which it was lifted. Stop number 2. The relevant records of the case which contains the where is that clause you have shown me?
12.
Which contains clause 12 of the contract agreement, which has been reproduced at paragraph 19 of the counter affidavit. Stop number 3. Whether any dispute review expert bracket board has been constituted, public appointed, by the respondent authorities in terms of the conditions of contract stop, if so, comma, a copy of the notification by which the dispute review expert of bracket board has been appointed. Stop, if not, comma, at what point of time should, not required. If not, you cancel it, okay? So the rejoinder affidavit has been filed. You have not
Lordship.
filed any further
No, ma'am.
additional counter affidavit,
No,
isn't it?
Yes, ma'am.
Next
Lordship,
para.
the office memorandum,
Huh?
the authority under which the office memorandum dated 15 February 2024 for scaling down.
No, this is up to him. I don't think there's any such kind of provision which says so. This he will submit. I don't think there's any such kind of requirement to direct him to produce whatever. If there is, he will produce. If there is no, then you have to argue.
Yes, ma'am.
Next para, the above instructions be obtained by the next date by the learned additional AG. List again. When do we have it?
23rd, next Thursday, ma'am.
Thursday. That'll be too late, Mr. Additional AG. Have it on Tuesday, 21st.
21st, ma'am.
List again on 21st of July.
Item number 8.
May it please your lordship, I am appearing on behalf of the state respondents. Your lordship, I have been directed to seek further instructions. Your lordship, I have sought the instructions. However, the education department is yet to give me written instructions. So your lordship, if I may be granted at least another week's time to file the necessary documents in the form of an affidavit.
Instructions by which order? I think 19.5, you had made some submission that you require more clarification,
Yes, your lordship.
correct? So you still don't have the instruction?
No, your lordship. I had sought for it yesterday also from the superintendent, and they have said that they are still collecting the documents.
Then what about respondent number 5? Has the notice been served?
Yes, my lord. Service was completed in respect of the respondent number 5.
How do you say that? How do you say it's complete?
We had checked from the the file, my lord. It was said like that, my lord.
The file or the office note
And we
says,
also,
office note says, AD card not yet received from respondent number 5. Matter is laid before the bench for admission hearing as a fixed item. So, not yet, AD card not yet received means not yet served. What you mean is that you have taken steps.
we have taken
The
steps. and we
registry
have-
has sent it by speed post.
Exactly, my
That
lord.
does not amount to notice being served. AD card has to come back.
That is correct, my lord.
So,
That we also track we do the postal tracking, my lord. The report said that it was delivered.
where is the postal tracking?
That copy was not available, only from the internet we had checked that.
You have checked it. You should have taken out a printout.
Yes, that is.
You have not taken a printout.
Yeah.
It's not that we don't believe you, but you should have taken
lord,
out a printout
I
that this is the confirmation that he has received or the item has been delivered. Notice was sent as far back as on. See the correspondence file. I mean, what kind of office note is prepared? I don't know. When was it sent? Date of sending it from the post office? (16/6). Please write. Office note dated 3/6/2026 indicates that neither AD card nor unserved notice has come back from respondent number 5. Stop. Office shall track the postal consignment and put up a note by the next date. List the matter again after when? After 2
Lordship,
weeks?
if 2 weeks may be granted, yes,
After
Your
2
Lordship.
weeks. The learned government advocate, Ms. Lal Nundui, shall also obtain necessary instructions by then.
Much obliged, Your Lordship.
Item number 9.
Yes,
No,
9.
Yes, Your Lordship. I'm appearing on behalf of the state respondents. Your Lordship, we have received the instructions. The affidavit in opposition has been prepared. However, there are certain documents which are illegible and there are certain documents which require translation. Hence, Your Lordship, if we may be granted another 2 weeks' time to file our affidavit.
5 has filed,
Yes, Your Lordship.
6 to 36 has filed. 1, 2, 3, 4 are to file.
Yes, Your Lordship.
How much time?
Your Lordship, if 2 weeks' time may be
2
granted.
weeks time. Mr. Ramzawa,
Lordship.
they want some time.
Oh, no objection, Lordship. We may also like to file reply to the affidavit of the
Any interim order
respondents,
in this case?
6 to 36.
Yes, Your Lordship.
Any interim order?
Yes, yes.
What is the interim order?
The staying the operation of the impugn order dated 21/8/2025 till today. Lordship, this may be extended.
Ms. Lal Nundui, learned government advocate, appearing for respondent numbers 1 to 4. Apart from respondent number 5, submits that she may be given 2 weeks' time to file the counter affidavit of respondent numbers 1 to 4. Stop. Mr. Asil Ramzao, learned senior counsel, appearing for the petitioners, also submit that he requires similar amount of time to file rejoinder affidavit. Next para, in view of above, the matter stands adjourned to be listed again. We'll have a date. It will be listed again on 28th of July,
Yes, Your Lordship.
2026. Parties to exchange their pleadings in the meantime. Interim order passed earlier shall continue till the next date of listing.
Much obliged, Your Lordship.
Item number 10.
Yes.
May I please, Your Lordship? Lordship, I'm appearing on behalf of my senior for the respondent number 4 to 6, my lord. And I'm seeking 2 weeks' time, my lord, to file my affidavit.
4 to 6. In the IA.
In the main, my lord. Oh, item
What
10.
is this matter?
My lords, this is the MPSC veterinary service recruitment. By the MPSC.
Recruitment.
My lords. In the veterinary service, my lords.
You're challenging the recruitment process.
Correct, my lords.
Okay.
Your Lordship, I'll be appearing for the newly impleted private respondents 7 to 10 years.
7 to 10.
Yes. I've filed my power today, Your Lordship. So if I also may be given some time to file the affidavit. In the 2 weeks.
Miss Daphne Lal
Shoitlongi, my lord.
Shoitlongi,
Yes, my lord.
appearing on behalf of Mr. J.C. Nunsanga, learned counsel representing respondent numbers 4 to 6, submits that she may be granted
2 weeks' time, my
2
lord.
weeks' time to file the counter affidavit of the respondents they represent. Stop. Mr. A.R. Malhotra, learned counsel, submits that he has instructions to appear on behalf of respondent numbers 7 to 10, and that he has filed his power when?
Today.
Today. He also prays that he may be granted 2 weeks' time to file the counter affidavit. Stop. Mr. Lal Sanhima, Silo,
Correct, my lords.
learned counsel, appears for the petitioners, and he has no objection to the prayer made. In view of above, matter stands adjourned to be listed again on 30th of July 2026. The respondents consent to file their counter affidavit in meantime. But likewise, the petitioners may also file rejoinder affidavit if so advised.
Obliged, my lords.
Any interim order?
No, my lords.
Up to hearing item number 1.
Your Lordship, this matter, I mean, if it can come up on Thursday, then
This Thursday, next Thursday.
coming Thursday, day after. It's in the list.
We'll see. Thursday, I think there are other cases also
Yes.
on that day.
Yes.
Correct?
In fact, this is a very short matter, Your Lordship. Anyway, the learned counsel was here.
Who is the counsel?
My senior Zoram Chana had to leave due to some personal matters.
Okay, we'll see.
Yes.
No order is required.
Yes, no order.